Yes! Hello, my beautiful friends, and welcome back. I hope that your week has been outstanding. Very glad that you're joining us here on a little bit of an early show. We've got some big updates today. We're going back to the Supreme Court on some election news. We got the red states that are racing on in there to try to get SCOTUS to reverse some of these lower level activist judges. We'll take a look at what's inside, talk about the latest on the SAVE Act as the Senate pushes forward to get it through. Then we've got an update on TPS and Amnesty. That was officially canceled, and the Democrats did some interesting shenanigans to try to extend some amnesty to all of these foreigners here on a temporary basis. They wanted to make it a lot more permanent. And we'll get the latest on that. We've got some blockages happening and reaction. We've got activist judges being stayed down out of the First Circuit, and a bunch of good updates there, including an effort against Boasberg, one of the most activist judges that we have. Now we've got some updates on the Alien Terrorist Removal Court. We know that that is unprecedented, never been used before. Docket is now filling up. They've got a hearing scheduled today, and we've got a bunch of the documents queued up, as well as the family members who were associated with this alien terrorist, and we have an identity of the person who is now in this removal proceeding. And then lastly, we'll take a look at the Tyler Robinson filing. The prosecutors came out and dropped their brief, arguing that there is probable cause. We hit the highlights of all of the preliminary hearings that took place. We had 5 days of argument and evidence that was presented, and we'll see what the prosecution says. And then, of course, the defense will have their response, and we'll be very interested to take a look at what is inside. And of course, we'll weigh out both sides of the argument, see what the evidence says, and of course, see what you say about it. But we're grateful to be here. We are a little bit early today. We've got a kind of a jammed afternoon with some other immovable objects that we can't move. And we've got no baby. So we're waiting for the baby to come out. Alexis is feeling maybe a little bit of like tingling or some waves or something. So we might be inching closer, but no baby yet. So we're still waiting for that little creature to come out. And so thanks for asking about it. We're super excited. Kind of on pins and needles here, waiting for this little baby to come. And so hopefully very soon. But we've got some business to attend to today in the meantime, and some very good stories that we will parse through and see what you have to say. A lot of Fauci fallout yesterday as well. And so we'll be back tomorrow morning with another guest in the morning called Hans Monkey, very smart guy, to debrief some more of the Fauci stuff. But in the meantime, we got some very interesting updates here today. And so let's get right to it. Looks like we're coming through loud and clear. And my friends, thank you for joining us. What a lovely day. All right, so let's get right to it, because we're going to the Supreme Court. The red states are now at the Supreme Court in support of President Trump's executive order. We know we want SCOTUS to allow the executive order to move forward. The Democrats, their committees, the leftist lawyers, all the blue states and more have been fighting overtime to stop any election integrity reform from actually manifesting. But now we're at SCOTUS, and a lot of the stuff we've been covering has been percolating for months now, and here we are. And the red states are now making their way inside. And you can see from SCOTUS Wire, they're explaining that we want the election executive order restored. We had the two main components, which was the citizenship lists and the Postal Service rule changes, so that we can have some ballot security and some chain of custody as we're picking up the ballots and delivering the ballots, making sure that they're properly marked. And so this is the document that we're going to go through. But while this is all happening, as we know, this could be solved if the Senate could just get the Save America Act passed. And they're still fighting for that. Here is Senator Jim Banks, who's making the argument. The Senate is just on the verge of recess, and they're saying we still can get it done. Cancel the recess. We don't need to leave town until we get this through.
If we don't pass it, the politics are going to be really bad for us at the ballot box in the midterm election. I fully agree with you, but we have an opportunity, and right in front of us, James Braid, the Deputy Chief of Staff at the White House, and Russ Vought, the director of OMB, came to our Republican Senate lunch today and laid out the pathway forward. And it's this reconciliation bill that the House passed over to the Senate. We need to pass it right now before we take a recess.
Yeah.
and get the reconciliation bill passed to fund the military, pass the Save America Act, voter ID in our elections. And if we do that, we'll win big in the midterm election on November 3rd.
Yeah, so you're saying no vacay until you get the Save America Act and the rest of it.
Stay home. Stay
I think
here.
that's a big part of our victory. I mean, on top of the big,
no
beautiful
vacation.
bill last
No
year.
vacation.
No vacation. No recess. By the way, there's a growing chorus. I think a third of the Republicans in the Senate have said this out loud. No recess. Pass the Save America Act. That's what our voters expect us to do. The voter ID, the Save America Act is an 80-20 issue. This is a winning issue for Republicans, and it's the right thing to do. The biggest news in the last week was the Democrat governor in New Jersey admitting out loud that 6,600 illegals were placed on the voter rolls in New Jersey, and that hundreds of them voted in the 2023 and 2024 elections in New Jersey. If that's not the biggest reason I've heard yet to pass the Save America Act, to stop illegals from voting in our elections, our American elections should only be for Americans. I don't know that there's been a better reason I've seen yet than that to pass the Save America Act and to pass it right now.
Yeah, and let's not forget that Mikey Sherrill, the governor in New Jersey, is literally protecting the non-citizens, the people who committed federal crimes, the 400 of them, which is probably a lot more than that number, who she confirmed actually voted in the elections. She says, we're not going to give Harmeet Dillon or the DOJ any evidence of their crimes, saying it's a privacy right issue and that she's not going to allow New Jerseyans to have their rights abused. And we're asking ourselves, they're literally criminals, according to your own documents. And it's different. It's not just that they were illegitimately registered due to a software glitch by accident, oversight, or somebody didn't catch it. They got registered. That's one half of the problem. Then they got ballots that were shipped over to them, and they know they're non-citizens. They know they're not supposed to be voting, and they got the ballots. They voted anyways. So we've got a real problem in our elections, especially when the people who are admitting that there are problems are also obstructing the enforcement of the law and then turning around in the same breath and saying, trust us, we're investigating ourselves, and we're going to come to a reasonable conclusion to make sure this doesn't happen again. It's like you're literally facilitating and obstructing prosecution of federal crimes. So you want us to trust you? We don't. So the red states are now jumping in. And what's always evident in these types of cases is when the blue states come in, the courts are very amicable to them. They say, well, you know, you have standing, you have legitimacy, you can sue right now, even though the rules aren't in effect. And so now the red states are also knocking on the door of the Supreme Court. And that means the Supreme Court needs to do something about this. Okay, we've got states versus states. We've got Alabama versus California. The Supreme Court has original jurisdiction over these types of arguments to settle disputes amongst the states. And so they better give us some response on this, and hopefully soon. But here's what the states had to say. And it's a bunch of the reds. And we saw something very similar to this back in 2020 when a bunch of states sued into the Supreme Court to challenge the election. And the Supreme Court rejected the arguments. They just said, we're not interested. Joe Biden's the president, and we'll leave it at that. So here's the list of the red states. Not a massive filing. The filing is 116 pages, but the arguments from Team Red are pretty succinct. You see, we've got Alabama, Florida, Indiana, Kansas, Louisiana, Missouri, Montana, Texas, and more, all coming in versus the blues. Connecticut, Massachusetts, California, Arizona, which just pains me, Virginia, Wisconsin, and of course, Pennsylvania, all taking their positions inside the ring. And so here's what they say. All right, listen, Supreme Court, we need you to stay the lower level judges. They are activist judges. They are impeding the president's executive order, and they're doing it because they know that as soon as this rule comes into effect, that they won't be able to do this anymore. When the Postal Service finalizes the rule and it becomes operative, then a lawsuit will have to go through a different avenue. It's going to have to go through the Postal Service Commissionary Body, Commission, and they'll have to then investigate it before they can come back into the Article 3 courts and sue. So they need to preempt it, which is why they filed instantly. And they say, Judge, Supreme Court, this lower level judge, the district court, issued a bizarre injunction prohibiting federal agencies from implementing Trump's executive order. But let's not forget, the EO imposes no obligations on the states. All they're doing is changing how the executive branch operates. And of course, that's Trump's branch, not California's. It doesn't change anything to the public. All it does is merely instruct, these are the states making the argument, not Trump, merely instructs federal agencies to consider potential reforms that further election integrity. But as we know, the lower courts enjoined the EO based on rampant speculation about potential future federal policies. All hypotheticals in the future. These aren't even finalized. These aren't even put into effect. In fact, the lower level courts admitted this point, saying, well, quote, there are clearly many uncertainties as to how the agencies will ultimately implement the EO, but we're going to injunct it anyways. Now, in enjoining this anyways, the district court violated Article 3 standing principles, stepping outside of their lawful authority to go attack the executive branch in Article 2. So we're going to examine this in 3 points, they say, and make this very clear to you, SCOTUS. First, let's start with their challenge to Section 2A. All 2A of Trump's order does is instructs the federal agencies to consider whether and how to create lists of voting age eligible citizens in each state. Homeland is going to make their own list. That's it. They'll transmit the list to the states. And the states, these are the states arguing, saying, we retain the option of whether to use them. Maybe we won't even use them. We'll say your lists are crap. We're not going to actually implement anything with them at all. The district court, though, speculated, she said, Talwani and the others, that these lists will be inaccurate and potentially cause the states to remove eligible voters from the registration rolls. Speculation on speculation. So once the rule goes into effect, once there is a list, it's presuming the state will accept the list. Then it's presuming that the state will actually remove legitimate voters when they validate and cross-reference them against the list. And why would the states do that? Like the states will just be like automatons and just say, oh, we're going to substitute your list for our list. No, there's going to be a check and balance. The state will validate what the list says and then only make removals that are legitimate against the list. But at the time the respondent sued, these important details about the policy were not even set yet. And remember, the Democrat Senate committee sued, all the blue states sued, multiple cases have been percolating through. We've won bits and pieces of some others, gotten reversals in some other courts of appeals. Now, that is true even now. For example, the parties still don't know which databases Homeland and these other agencies will use. Hasn't been finalized. Don't know whether the databases will be inaccurate and whether or how each individual state would even use the list. You're presuming all of these things are happening. That's going to be the harm. And so you can't even think about the rules. You can't even discuss the rules that you're going to implement because all of these 4 things might happen. Clearly showing how speculative and hypothetical it is. Then, Section 2B then says that the AG, this is from Trump's order, directs the AG to prioritize the investigation and the prosecution of others who send ballots to people not eligible to vote. Okay, this is Mikey Sherrill in New Jersey. New Jersey sent 6,600 people. Presumably all of them got ballots. They were all registered. They're all ineligible outright by their own admission to vote. And 400 of them did. And they're not even cooperating with the feds to prevent that from happening again or to get justice for those voters who had their votes displaced by the non-citizens who cast ballots. So in other words, all it does is prioritize long-standing federal election laws. It's already illegal. We're not inventing anything. Even assuming that they can challenge the government's prosecutorial discretion at the AG's office, they can't show any actual or imminent injury from the enforcement of unchallenged election laws, especially given the fact that they do not even allege any intent to violate any laws or that any individual has been investigated pursuant to the EO. So there has been no actual harm, but they're saying there could be, and so therefore we can't even contemplate the rules. So speculation also dominates. These are the red states writing about the Section 3B. This is the Postal Service rulemaking potential. They want to reform and strengthen the security of mail-in voting. The federal government and the Postal Service does not have to facilitate criminal activity in the mail. They don't have to send cocaine through the mail. They don't have to send, that's a crime. You don't have to send a fraudulent ballot through the mail. So they want to strengthen the rules. Now, since the Democrats filed suit and got relief, Postal Service has issued a proposed rule, one that we read here, very different than what they predicted. And contrary to their complaint in their original filing, they said the proposed rule would do a bunch of bad things, but it doesn't. It doesn't grant federal agencies, quote, according to their complaint, decisive control of the list and preventing the states from ensuring accuracy. It doesn't do that at all. In fact, the opposite. The proposed rule provides the states, not Postal Service or any part of the federal government, the states retain full control over who or who would not be able to vote in the elections. States would control the enrollment of the list. Okay, Homeland makes the list, sends it over to the Postal Service. Then the state can say, your list is bad. We'd like to supplement it and add all of these people to it. Great. All of those people that the state adds will get a ballot. So you still have control. All you got to do is add them to the list. Now, even now, the parties are jousting over potential policies in a proposed rule. And it is already black letter law that says proposed rules are not ripe for a lawsuit. We're just thinking about it and commenting about how this could be implemented. But again, if the rule is implemented, they say, oh, it's final now. Then it becomes a Postal Service rule and they can't sue in an Article 3 court and go to an Obama judge like Talwani or a Trinidad and Tobago judge like Sparkle or Zenas or any one of these other judges like Murphy and get them to reverse this. They'd have to go through a different avenue, and they don't want to do that. They'd rather just forum shop, get the right judges who will then assist them in their election obstruction and call it a game. Now, after all, this proposed rule could easily change as a result of the rulemaking. Courts do not ask, as the respondents asks, to presume that the agency is going to break the law. Indeed, Postal Service must consider changes in response to the comments. And only after the Postal Service finalizes its rules, then can they challenge it, which is really what they don't want. Because only then will they actually know what the rule is. And so, Supreme Court, these are the red states speaking. We have a say in this country as well. You should reaffirm fundamental Article 3 standing principles and enter a stay. Stop this activism from down below. Now, setting aside the merits, the government and the state defendants, we easily meet the requirements for a stay. On their side of the irreparable harm balance, okay, both sides are saying it's going to harm us. If you actually prohibit this from going into effect, it's going to harm the elections, and the red states are unhappy about it. The blue states are saying the same. You're going to harm us. So how do we balance it out? Well, they can only point to speculative injuries. These are non-final policies, and they can challenge it when it does become final. Now, on the other side, the federal government and the states, they're irreparably harmed. We don't even have a chance to lawfully implement the policy agenda of the president who was duly elected. And the state defendants, the red states, are irreparably harmed. They're being blocked. Okay, the blue states are saying you might, at some hypothetical, disenfranchise a legitimate voter. The red states say that's okay, that's all speculative. You're literally harming us right now. We want to access the state lists. We want to benefit from the reforms in 3B that could strengthen the security of mail-in voting. And finally, you should hear this case because it is cert-worthy. There's other cases and other parts of the injunctions were also stayed by the D.C. Circuit Court of Appeals, which we covered earlier this week. So now we start to see kind of a little bit of a splitting going on, right? Some judges are injuncting and stopping portions of the EO. Others are saying it's not ripe enough, like we saw out of D.C. And so you need to settle this. And more broadly, this case is part of a growing trend whereby litigants challenge Trump's orders instead of waiting to sue over finalized agency policies. And so you, Supreme Court, Amy Coney Barrett and John Roberts, you should check that trend. What these judges are doing is undermining core Article 3 standing rules, and it cannot be allowed. And so we know the facts here. We've talked about this a lot. We'll go through this quickly. But remember, in March, Trump did the EO. We've got the citizenship lists, which are going to be beautiful. They're furious about the lists because the lists are how you rig the elections. Every case, every election problem that we've talked about, you can trace them all back to the lists. We also then have a priority of prosecution that will be deployed. So people like Mikey Sherrill from New Jersey will come under scrutiny at a higher priority than somebody else. Third, we've got the rulemaking for the Postal Service, and the states interface with the Postal Service so they can add people onto the list to make sure that the ballots get delivered here. Now, it also provides in the EO that the preparation and transmission of the list, all of it shall follow the law, including privacy rules, and creates a whole procedure that allows the states to supplement the list so that nobody's getting disenfranchised. Now, there is no final rule even now, Supreme Court. On June 2nd, the Postal Service published its notice of proposed rulemaking. Under the proposed rule for the mail, they would not send mail-in ballots to people who are not on the list. Okay, we're not going to facilitate fraud. Get on the list or don't get a ballot. And states, not the Postal Service or any federal agency, they would control who's on the list. They say, we want to add all these people, you can. Now, the president promulgated this. Then the lower level courts started to prohibit it. We filed a bunch of appeals and have been litigating this for a long time. We have now finally appealed, and we're here in front of the Supreme Court. And now we are going to win. We ask that you accept this case. We think there's a reasonable probability that 4 judges will consider the issue meritorious and grant access of cert. Allow us to come here. We also think that in addition to the 4, there's a fair prospect that a majority of the court will reverse the lower level judge. And also, if you don't do it, there's going to be irreparable harm for us. And by the way, you should also dismiss this because the respondents lack standing to even challenge it. The blue states shouldn't even be here. And if you balance the equities, it favors the red states, not the blue states, and the federal government. And you need to actually hear this because we've got a little bit of a split here. We've got the DC Circuit and the First Circuit. First Circuit was handing some wins to Team Blue. DC Circuit, I know surprisingly, was handing wins to Team Red. And so you should hear this to fix this. We've got a growing trend of lawsuits brought by the Democratic Party and leftists to stop any of this from going into effect. Now, they don't have standing. They need to allege in order to sue that they have an injury, and it needs to be traceable back to Trump's actions. An injury, in fact, means it's an actual injury. Otherwise, we're just hearing cases based on speculation and hypotheticals. There is no actual case and controversy. It's just kind of whimsical, people discussing what may or may not happen. Now, even if standing exists, which it doesn't, courts should not resolve challenges that are unripe. We need the case to actually have a problem. And so both doctrines demand the lower level judge is stayed and then ultimately reversed. Now, the reason they lack standing as to this is for a painfully obvious reason. Even assuming the government finalizes the policy, there is zero obligation on any state at all. The EO is clear that any use of the citizenship list is optional. Don't even have to use it. It merely orders that we create the list and provide information to you. And if you don't want to use it, don't use it. So given that reality, they can't identify any actual injury that's happening to them. Now, unsurprisingly, of course, they failed to articulate a cogent theory of standing. In their complaint, they say it's harming us because it transgresses the state's constitutional power to prescribe time, place, and manner of federal elections. And it's an attempt to coerce us. And you're going to force us to act contrary to our state laws in California. But that is utterly implausible, they say, because nothing in the order proscribes the states from doing anything or mandates them to do anything. They're not stopped and they're not ordered. So they also say it's going to harm them by introducing chaos. And now it's going to make us have to revisit this and go onto the portal and add a bunch of people and upload things. They say this would harm the state because citizens who access their records and find that they're not going to get a mail-in ballot are going to call our office and they're going to say, wait, I'm not on the list. I'm not getting a mail-in ballot. So what do? They'll call the secretary and they'll overwhelm them. But courts routinely reject this kind of standing. It relies on speculation about some third party. And so you should reject that because everybody would just come in here and say, oh, it's chaos. Any change is going to require more efforts from us. And therefore, you're not allowed to make the change. Now, for its part, the First Circuit, which was on Team Blue, they said that it was going to force the states to expend resources. That's the harm. But again, this is implausible. It allows them to ignore this. They don't have to use them. And to the extent that the election officials are voluntarily choosing to divert resources, that's a self-inflicted injury. They don't have to use it. And for them to say, well, if we decide to use it, we make the volitional optional decision to do it, it's going to be a lot of work for us. You're going to the cause. You would be making the analysis that the costs outweigh the benefits or the benefits outweigh the costs and then use it. Now, even assuming that they have identified an injury, claim is not ripe anyways. There is no actual or imminent injury. And they lack standing where it's all about speculation. All of this is clearly true here. At the time the blue states sued, and still today, the government hasn't finalized anything. It's still up in the air. What databases are we going to use? How are we going to comply with the Privacy Act? What information is going to be considered routine use? Will the citizenship list be circulated at all? Given the command to create only lists that are consistent with the laws and the Privacy Acts and more. And even the lower court admitted there are many uncertainties about how this will all go down. And so we should have extended that statement to its logical conclusion. If there are uncertainties, then it's not actual, it's not imminent. And by the way, you addressed a nearly identical fact pattern in Trump versus New York back in 2020. Just as this case in Section 2A qualifies its directive under Homeland, back in 2020, this was the census case about congressional apportionment regulation. We litigated the same thing, and you said that was no more than conjecture. Okay, they sued, they didn't like the census analysis changes, and the Supreme Court said, there's no actual case here, so get out of here. Same thing's happening here. Until the federal government makes a formal determination that this can be lawfully implemented, all of this is premature from Talwani down below. And they asked her to assume that the citizenship list will be based on the SAVE database, and that it's going to be inaccurate because the SAVE database, not to be confused with the SAVE Act, is purportedly incomplete. And so therefore somebody will suffer somewhere. But even assuming that there are inaccuracies in the main database, the law under Trump's order makes clear that the list could be based on other sources of information. We could go to naturalization records. We could go to Social Security records. Any other relevant databases like SAVE data, we could cross-reference these things. And so they don't even know what they're using. So their challenge is riddled with contingencies. It's filled with speculation. And that's why you should stay the lower court and allow us to march this forward. Similarly, the AG has been instructed to investigate the criminals, and fear of any prosecution would not be redressed here. Even if you prohibit us from prioritizing this, it doesn't stop the federal government from enforcing laws. And so that is not sufficient. Now, respondents have also failed the blue states that there is any actual imminent risk of prosecution. No evidence that any individual, let alone a state official, has been criminally investigated, although they should be, including Mikey. It is hard to imagine the prosecutions happening given that respondents do not dispute that only age of citizens can vote, and the provision of fraudulent ballots is unlawful, right? They're saying, blue states, why would we prosecute you? You say there are no non-citizens voting. You say there are no felons or dead people voting. So if there's voter fraud happening, we would prosecute it, but you say there's no voter fraud happening. And so if there's not, then what are you fearful of? What's the injury? Since you say it's not happening. But regardless of how they read this, their irrational fear of prosecution doesn't give them standing. Prosecution and fears of it doesn't mean you can sue to stop the prosecution of criminal law. And so this has also been weakened. We've seen other Supreme Court cases that have come down. And so that, again, is another reason to stay Talwani. Now, lastly, under Section 3B, it is black letter law that you cannot challenge proposed regulations. You already decided that in the Bennett case, in the Murray Energy Corp case. You've got 5 U.S. Code 704. You have to have a case in controversy. That means sufficiently concrete challenged policy to assess the imminence of the injury. And this should be rigorously enforced. In allowing ongoing proceedings to be completed, you respect the executive branch. And they're not. They're trying to impede the executive branch. They sued based on a proposed rule, and not even a proposed rule existed at the time they sued. And the lower court entered an injunction to stop that. What that is an advisory opinion, and you're not allowed to do that. It's a prohibition on a hypothetical policy that isn't even existing. So it directs the EO only to initiate rulemaking. And then after the notice and comment period, policies can and often do change because they incorporate those suggestions. And the entire order says, follow the law, including state law. And so it's all still being contemplated. But the First Circuit, they concluded otherwise. They said, well, they're still going to have to divert resources in order to deal with this. But again, that is a diversion that is speculative. They're making the decision to do that. And so this case demonstrates the wisdom of the traditional rule that you gotta wait until the rules are final before you sue. Since they filed a suit and got an injunction on a different rule that they were contemplating, this is invalid. Under the rule that's being considered, the states, not the Postal Service, would retain control. And so again, they are arguing based on something that is not even real. Now, the other stay factors favor our side. The stay applicants have demonstrated irreparable harm. Of course, the government and the American people are clearly harmed when courts impede the executive branch. We elected the people in the executive branch. The country did. For the people constantly lecturing us about democracy, they don't seem to care. Additionally, the defendants, the red states, are also harmed because we can't get the benefit of these changes that many of our people voted for. Allowing the government to finish their rules on election integrity helps our states, and we cannot themselves implement, as the red states, some of these common sense proposed reforms. We don't control the Postal Service, so we need Trump to make these changes, and we want them. Now, on their side of the balance, on Team Blue, they are only speculating about this. They're worried about final agency actions, and there is no harm to them at all. But we have a strong interest in getting this done. Presidents frequently articulate policy objectives, and then the agencies implement them. And we don't want to entertain speculative challenges, and so that's why you should hear this case SCOTUS. To start, 2 panels in the D.C. Circuit have already split with the First Circuit on whether it's too early, and just today, the D.C. Circuit affirmed Judge Carl Nichols. He said Team Red wins. It's not ripe enough. Then another panel stayed, and again, back and forth. So this circuit split shows Supreme Court, you got to pay attention to this. And more broadly, this underscores the need of SCOTUS to police. You got to slap this down. A growing trend of courts that are now granting injunctions against non-self-executing Trump EOs. Look at all these cases. Federal government employees, LULAC, National Association of Diversity Officers in Higher Ed. That's an organization. The National Association of Diversity Officers. Oh my gosh, could you imagine being in that room? This trend threatens to undermine Article 3 principles. You, Supreme Court, have said time and again, people and litigants cannot bring lawsuits based on hypotheticals. And so there is no exemption for this. And here, a directive from the president is subject to change, and they can sue after it is implemented. And so for the foregoing reasons, tell Judge Talwani out of Massachusetts she has stayed and grant an immediate access to this case in the Supreme Court, signed here by the red states, Alabama, Indiana. We've got Montana, Kansas, Louisiana, Nebraska, South Dakota, Oklahoma, and many more, including Texas in the House. And so all of that now working its way up to the Supreme Court. We've got elections coming down the pike very soon. And why are the red states not getting the benefit of these changes? They want secure elections. They want integrity when the primaries and the midterms come, and then 2028. So they should have a say in this. Currently, the lower courts have just been largely diverting to Team Blue. And so hopefully SCOTUS comes in and clears this up. But another way to fix it is with the Save America Act. And so Based Mike Lee, of course, is out. He says this is not going away, nor are the American people. No matter how much Democrats try to import new voters for themselves, which they are doing, they may no longer pretend to care about foreign election interference. They don't even think it's a problem. In fact, some locations like LA County, they want non-citizens to be voting in their school board meetings and things like that because they care more about them than they do American citizens. But here's Mike Lee explaining this on the floor of the Senate.
Mr. President, this issue isn't going away. The Save America Act isn't going away. Voter ID requirement demands are not going away. I will be back. I will be back day after day, week after week until this passes.
Let's go.
Because the American people deserve to go to bed every night knowing that their government is run by people they themselves elected, not foreign nationals. They don't want a government that has been chosen with significant foreign influence in our elections. There was a time, Mr. President, when the Democrats in this august chamber, a time not so very long ago indeed, spoke of little else other than their fear of foreign election interference. Mr. President, if we don't face a real challenge as to foreign election interference right now, as long as we are not passing the Save America Act or its key components, it would appear that those who are against this are just fine now with foreign election interference. The American people shouldn't be. Because again, it's not free. When somebody else votes who's not who they claim to be, when somebody else votes claiming to be a citizen and they're not a citizen, it robs hardworking Americans, actual American citizens, of their most sacred, their most fundamental right, their right to vote.
Yep.
No, Mr. President, we can't look the other way.
No, we can't.
Nor do we, in my view, have any business taking a 6-week recess until such time as we've done everything humanly possible to get these reforms put into law. This will not disappear simply because we leave. The cavalry's not coming. We are the cavalry. There are no house elves who will come in and fix our election security problems. So let's get this done, and for the love of all that is sacred and holy, let's not go on a 6-week recess with all of this undone. The American people deserve better.
Thank you, Base Mike Lee. He's absolutely right about that. Hopefully those words go into John Thune's earlobes and shake something loose in there. We'll see what ultimately happens, but we've got multiple vectors now underway to fix our elections. They're working on it in the Senate. We've got the red states jumping into the game. We've got Trump with his executive order trying to fix things at the federal level. And now we've got admissions from the blue states that they do have non-citizens on their rolls due to glitches. And they're obstructing the prosecution of the voters who were non-citizens who stripped away the equal vote of an actual citizen. And they don't want to explain how it happened. They don't want to reveal any evidence about who did it and where they did it, or even retract those votes, because they are part of the cover-up, part of the obstruction, and part of the fraud. But we're going to keep our eye on this one. We'll see what the Supreme Court does as this case continues to percolate. Shout out to the red states. Happy to see them jump in and fight for election integrity at the highest of high levels. And once we get some updates, we'll be back with more. All right, now, let's turn our attention to some other good news on the day. Democrats just got crushed. They're fuming mad that Trump canceled TPS status for huge swaths of their constituencies. And they did everything that they possibly could to prevent that from happening. We saw this case had to go all the way up to the Supreme Court until SCOTUS slapped down the lower court judges and said, you don't get to substitute your judgment for the president's judgment in canceling TPS. It is a power ensconced in statute. Congress said that they could do this and courts could not interfere, but they did. And so now that the cancellations have been underway, we've seen the Democrats working in overtime to extend it and to essentially give, especially the Haitians, mass amnesty. But the order is official, and the Democrat amnesty just got blocked. Here's what USCIS had to say, posting this one with an update this week saying, after reviewing country conditions and consulting with the appropriate government agencies, Kristi Noem said that Haiti is no longer a group that met the conditions for TPS and terminated it. Then the lower level activist judges interfered, and it went all the way up to the Supreme Court in Mullen versus Doe. And now TPS for the Haitians is hereby terminated, effective July 27th. Now, all of the forms and the beneficiaries that were granted to the Haitians employment authorization with all of these categories from A12 to C19 are no longer valid. Employers completing Form I-9 must re-verify TPS Haiti beneficiaries who are currently using these worker authorizations, and you cannot continue to employ a person who does not provide proof of current employment operation and authorization. No more work allowed. For any other details on this, check our website. And so what did the Democrats do, of course, is they did everything that they could possibly do to block the TPS order from going into effect and to grant mass amnesty. But Eric Schmidt prevented that from happening. He said last week, Democrats tried to pass a bill extending TPS, and I blocked it. Today, they tried something even worse. They tried a bill to grant mass amnesty to millions who previously had TPS, and I blocked that too. Temporary means temporary, period. Here's Eric Schmidt.
Mr. President, I object to this mass amnesty bill. Last week, Democrats asked the Senate to extend Haitian temporary protected status. Today, they've dropped the quotation marks. Instead of extending temporary status, this legislation would convert temporary status into permanent status. Green cards, permanent settlement. At least the bill last week continued the same old Washington lie. Today, Democrats finally admit what this scheme was always designed to be. Temporary was always meant to be permanent. It's the final stage of the scam. But that's how Democrats do mass amnesty. First, they declare an emergency. Then they import hundreds of thousands of people. They then extend the program over and over and over. Then they unleash activist lawyers against anyone who tries to enforce the deadline. And when the American people finally elect a president to end this chaos, to end this abuse, Democrats demand mass amnesty. And when the American people finally elect a president who enforces the law, Democrats change the law and hand out green cards. That's what this bill does.
And Joe Biden, in his final days, remember, extended TPS for everybody, added a bunch of people into certain categories of TPS, and they were going, if they could get it done, to wave in another 2.5 million people. They added another million, and they wanted another 2.5 million to make it about 3.5 million in Biden's final backstab on his way out. Because, of course, their entire goal is to shift the demographics of the country, create a constituency that is more in alignment with their communist ideology, that will rely on the Democratic Party to give them benefits like SNAP, housing, food, healthcare, everything that you've ever seen, and ultimately align them as voters for their perpetual quest for power. But they got blocked. Schmidt says not happening. Today, Schmidt took to the Senate floor to block the attempt to pass more legislation, allowing the Democrats wanted to allow certain previously removed aliens to apply for permanent residency from abroad. Okay, so they're gone, but now you can apply to actually become a permanent resident. They also wanted to pass a bill that would restrict information to be used in immigration proceedings and to make it more difficult for future administrations to end TPS designations. And Schmidt said no. And so all of that got blocked in a very nice effort from one senator, but we can see what the Democrats are up to. Now, as this cancellation has ended, you've got the Haitians reacting to this, and this was a clip shared over by Matt Van Swol over on X. And it was a clip from a local 10 news agency, which had an immigration attorney, apparently, who was talking about what's going on with the Haitians now that this status has come to a close.
I know for a fact no Haitian American is packing bags.
Lorna Rosenberg-Joseph is an immigration attorney who is telling her clients two things: not to panic and to have all necessary documents handy.
But how you act and what you say are two different things. So we've given them this avenue for so long. I think now we need to strategize. There needs to be some sort of relief.
You can't work, you can do nothing. You need a baby.
There's a sheer
You need a baby. Did you hear that? So you're here temporarily. We say your country had an earthquake 15 years ago. So we'll be nice. We'll extend a brotherly Christian arm out and take care of you while things are bad, but eventually you're going to have to go home, right? Sure, perfect. We'll come in. We know it's temporary. It's in the name. Then once they're here and the temporariness has expired, they don't respect your invitation. They say, we're not actually going to leave. She said, no Haitian is packing their bags. And the other lady says, you just need to have a baby. And once you have that baby, then that baby, of course, is an anchor baby. That baby comes out as a citizen, thanks to Amy Coney Barrett and John Roberts. And that creates a chain of migration. Then that child, they don't want to have the citizen child stay here while the parents are deported. So everybody stays together. And there is no removal, which is the whole point. Temporary, so that they can come here and build families for 15 years, and then you can't do anything about it.
Determination to stay, despite being exposed to deportation efforts. 350,000 TPS Haiti recipients in the U.S. had their work and driving privileges stripped away at midnight as the government allowed their protections to expire. The Department of Homeland Security posting this message on X that some people have deemed insensitive. Don't hesitate to repatriate, it says, offensive, along with the link on incentives to self-deport. This despite a level 4 do not travel advisory issued by the State Department for Haiti and widespread gang violence and homelessness in an already unstable Caribbean nation.
Great. So now we've got 350,000 people here who come from a country that looks like this. And when they come here, they're still fighting to stay here. And I don't see a lot of American flags out there, but I do think I see, is that a Haitian flag right there? Well, that's weird. So they're fighting for Haiti. Is that a Haitian flag? Flag of Haiti. Let's see. Oh, it is. Just as we suspected. And I think I see another one up here, and there might be another one over here. Wow, isn't that something? So the flag of Haiti, okay, they come into the country. We give them virtually everything because we're nice people. And then they're still out there waving around their Haitian flags on our streets, not even assimilating at all. And so now we have a situation where the people who come from this culture, where they're shooting people on the streets, burning stuff in the middle of the road, torching their own neighborhoods, are now here with their foreign countries' flags in our nation. And they say, well, they want to be Americans. They're migrating here. They're coming in to assimilate. No, they're not. I don't see an American flag anywhere in here. So that's part of the problem. That's why all of the gratuity, all of the graciousness that we extended as a matter of good faith now needs to be rescinded and they can go back home. So here's more. Another TPS group, I think this person came from Venezuela, ran over and killed a Florida grandmother. Wow. So here you see this was 100% preventable, according to Homeland Security, because these people should have never been in our country in the first place. And now a Florida grandmother is dead because we invited these people in. We didn't. Our corrupt governors and governing politicians did, saying it was going to be good for us, and it's not.
We're learning more about yesterday's tragic incident that claimed the life of an 82-year-old Panama City Beach woman. Friends and neighbors have identified her as Deborah Murphy. As News 13's Grace Velez tells us, Florida Highway Patrol troopers are still investigating the crash that took Murphy's life.
State troopers released a portion of the surveillance video showing the moments that led up to a deadly crash between an SUV and a woman walking out of a grocery store. The tragedy happened a few minutes before 1 Sunday afternoon in the parking lot of the public supermarket at the corner of Magnolia Beach Road and Navy Boulevard. Authorities believe 26-year-old Carlos Daniel Suarez Contreras from Atlanta, Georgia, was driving the black SUV. The video shows him pull forward, then stop. It then shows the victim, 82-year-old Deborah Murphy, walking out of the store with her groceries. At the same time, the driver puts the SUV in reverse, backing over Murphy. Troopers say the driver told them he never saw her. Both Suarez Contreras and his passenger, 29-year-old Luis Sanabria Perez, had ICE detainers. News 13 spoke with Murphy's neighbor, who shared these sweet photos. She said Murphy was the best neighbor, close friend, and was like a grandmother to their kids. She says Murphy was truly one of a kind and will be missed by the community. Murphy retired in Bay County and lived alone with her dog Maisie. Her daughter picked up Maisie on Monday.
And now she's dead because these two people were out on the street, should have never been out on the street, had a nice detainer, but they're running around rampant, just running over nice little old grandmothers with their dogs who are now no longer with us. And so all of it needs to end. They all have to go. It's just that simple. Now, while we're debating this, we had another lower level activist judge prevent TPS cancellations from going into effect. 3 of them, actually, all out of Massachusetts, one of the worst states for activist judges. And what we saw is that the Supreme Court already said you can't cancel Trump's cancellation. You can't reverse it. You can't stop it from going into effect. But they did anyways. They said that we're only going to stay it. We're going to make an administrative stay so that it is essentially paused, but we're not out of line with the Supreme Court ruling. Now, the First Circuit reversed them because the Supreme Court was very clear. These activist judges cannot impede this effort. So it's a big win on this one from the First Circuit. We've got the decision here queued up, very short one. But let's not forget we had a slew of these cases that all got bundled together. This one was African communities together. Mary Doe, David Doe, Jacob Doe, all these non-citizens who are now proceeding anonymously in our courts, taking advantage of our judicial system that they didn't build back home in their countries. Mark Wayne Mullen is the recipient of the lawsuit, and this went up on appeal and came back down. Now, it's a win. Previously, the Court of Appeals writes, upon the government's motion to lift the stay, the cancellation of TPS status came in this case for South Sudan, the lower court said, I am going to issue an administrative stay. So I'm going to pause the cancellation of the status, saying previously we lifted the abeyance of this appeal and denied an administrative stay of the district court's order postponing the cancellation of South Sudan TPS. But now, upon further briefing, we now reverse the postponement order because the Supreme Court decided this in Mullen versus Doe. Mullen held that the TPS statute's judicial review bar applies to all non-constitutional claims that challenges Homeland's determination when it comes to canceling TPS. So claims of that nature were the only basis for the postponement order on appeal. And so accordingly, the government's request for summary reversal from Homeland and Trump is allowed. Its additional request for a stay pending appeal is denied as moot, and the matter is remanded back down in light of and consistent with Mullen. And so it's going to go back down to the lower court with an instruction that your stay is inappropriate. Presumably. Now, the judge may still get sneaky about this, and he may try to find some other argument that undermines the cancellation, but it's a slapdown. Okay, he was being very clever. He was trying to say, oh, it's not a permanent stay, it's just an administrative stay. And an administrative stay is a stay that the court can use because it's more inherent in their ability to administer their own courts. It's not a constitutional claim. It's not a stay on any type of merits about like irreparable harm or imminent harm. It's just simply a mechanism of managing the court's calendar, right? So the administrative stay comes from a different power. He tried to use that. They say no. So send it back down. Mullen says that the argument that they made was only about these issues. Supreme Court said you can't substitute your judgment in time for these matters. And so it'll go back down. And as it stands, this one is a win out of the First Circuit. We'll see what the judge does and how sneaky he gets. But we also saw another very activist judge named Jeb Boasberg. This was the judge who ordered Trump to turn the airplanes around when they were filled up with foreign terrorists on the airplanes. Right early in Trump's administration, he started to deport these people, put them on airplanes, sent them down to El Salvador. Boasberg said, turn those planes around. You're violating these illegal alien terrorist due process rights, and you didn't give them enough process. So bring him back. And then he got slapped down twice by the Supreme Court and had a big back and forth with the administration. And so now we're asking, what are we going to do about these activist judges? And now Eric Schmidt is introducing the Boasberg Act to block judicial shopping, saying Eric Schmidt introduced a bill. It's called the Blocking Overt Attempts at Shopping by Enforcing Randomization Guidelines. Nice. It's called the Boasberg Act. It combats judicial bias by requiring courts to implement processes that randomly assign cases amongst the judges. Enforcing random case assignment will promote confidence rather than having judges just kind of wake up and say, I want that case. I'm going to take it, and tell Trump to turn the planes around. Boasberg said Schmidt is a poster child for a rogue judge and exposed serious loopholes in our judicial system. Randomly assigning cases among judges ensures the American people have confidence, and the Boasberg Act prevents judges from forcing their way into these cases. The act requires all courts to randomly assign civil cases to make sure that no party or judge can just shove themselves on. The bill also requires Circuit Court of Appeals panel to be assigned at random, stopping improper panel rigging that Schmidt has investigated. The bill also requires cases to be reassigned to a new judge if the Supreme Court overturns the original district judge's ruling, as happened with Boasberg multiple times. So you make a bad ruling, you get up on appeal, you get slapped down. It doesn't go back to that judge. Okay, case goes to somebody else, which is a good rule. The legislation also requires courts to publicly disclose their randomization procedures. And so all of this making its way through Congress in a new bill. It's a big 16-pager. You got the highlights of it, but Schmidt is advancing it, and we like its name, the Boasberg Bill. And hopefully, in addition to this, we get some more impeachments and more of these judges. Whether they're removed is a whole separate issue, but the point is you need to begin the process of accountability. And once they get impeached, they have that on their record. They're not going to be too happy about it. And Congress, I think, could also just remove them for bad behavior. But this has now been submitted. Randomness in the assignments of judges. But as it stands today, the Democrats just got blocked by Eric Schmidt, who's keeping his eye on the courts. TPS status is canceled for the Haitians. We've got some other wins out of the First Circuit saying that these administrative stays are not a valid reason to substitute your judgment in for the president and Homeland's decision to cancel these things. And so we'll see how this is implemented, because according to this one attorney, the Haitians who are here on our streets with their foreign flags are not packing their bags. And so maybe there'll be some incentives that are brought down to their communities in order to encourage them to go back to their great Haitian country. They can go swim in the water down there with Conan O'Brien and have a big coconut margarita and really enjoy the time there. Since they don't want to wave American flags, they can go wave their Haitian flags in Haiti. So we'll keep our eye on this story, all the TPS litigation and more. Thanks for joining and subscribing as we do. All right, now speaking of foreign alien terrorists, we've got some interesting ones on this one. The alien terrorist in this unprecedented court proceeding has now been identified, and we've never seen this court used in the history since its creation. Now it is busy. You can see a bunch of different items populating the docket. We'll take a look at this, and this was one of the courts that was referenced by Judge Boasberg saying, why don't you use that? Or rather, I'm not going to entertain your argument in my courtroom when Trump tried to remove illegal alien terrorists. And now it's underway. And so we're very interested to see who the very first alien terrorist is. Her name is now Nazera Haji Zada. And a lot of this has been classified up until today, but we do have some insight into exactly what was going on and whether or not she'll be sent on out of here pursuant to these powers. And this is just a little bit of a trial case. We know it's almost like a preview of what's to come. Once we can get a good cadence in this court, maybe we start to accelerate the docket and increase the deportations en masse. But here are a couple of the articles, the filings that hit the docket. You can see in the Alien Terrorist Court, which is a brand new court, you know how much we like that, saying the Attorney General now would like to unseal some things that we can take a look at. And there's a companion case of her family that has also been prosecuted, and he's already been sentenced and taken a guilty plea. So we'll take a look at all of that as well. Here's what they say is now unsealed. We want more items, including the certification of application for removal of Nazera Haji Zada, the unclassified ICE declaration in support of her being removed, and the unclassified summary as well, all signed here by Hayden P. O'Byrne, now acting deputy AG, assistant AG, on this court's list. So here's more. We've got an initial status hearing that has been set, and the court is saying that there will be some process to this, saying that the respondent under U.S. Code is entitled to a release hearing, and it's requested that the hearing be set at 4 p.m. on a day that is convenient for the court. Now, the verbal language of this person is not English. Of course, why would it be English? She's only in America, so of course it's something else. She speaks Dari. She speaks little, if any, English, and she is unable to read or write in any language. Great, glad she's here. As such, we request a Dari interpreter for this person, and she's going to need a lawyer appointed. And so all of that has been submitted as well. Then we get certification of removal, and Todd Blanche signed this one. That's a big name here on this type of a case. Todd Blanche saying, I'm certifying you can remove this person, and here's the background as to why. Saying, in the matter of Nazera Haji Zada out of the Alien Terrorist Court, they say Nazera is the subject of an FBI national security investigation and is being investigated for crimes related to international terrorism. FBI Oklahoma City became aware of Nazera in August 2024 as a result of FBI OC counterterrorism investigations into her son, Abdullah, who we have queued up and have his docket available. And son-in-law, another guy called Nasir, and their support for literally ISIS. Now, the FBI investigations revealed that Abdullah and Tawhidi, so the son and son-in-law, conspired to relocate their female and juvenile male family members, including Nazera, to ISIS territory in Afghanistan, while they would remain in the U.S. to conduct an attack on behalf of ISIS. On October 7, 24, Abdullah and Tawhidi were arrested by the FBI. They tried to buy firearms and ammo from an undercover FBI employee and then used those weapons in their attack. The FBI has now developed information that Nazera, this woman here, is a supporter of ISIS, has formally pledged loyalty to ISIS, supported the son and the son-in-law and their conspiracy. We're also further aware that Nazera, in collaboration with Tawhidi, worked to indoctrinate her children with ISIS ideology and to have them pledge loyalty to ISIS. Nazera also worked with Tawhidi to radicalize the family and to conceal their pro-ISIS teaching, and they planned family relocation to ISIS territory from her unsuspecting husband, Abdullah. This information was obtained from a reliable source who has provided reliable info in the past and whose reporting has been corroborated. Now, the underlying information is classified. Disclosure would enable terrorists and other organizations to avoid preventative and detection measures, or would reveal FBI or other IC sources and methods on how we got this information in the first place. And so, as we'll see, here is the actual affidavit that is now coming over in a declaration in support of removal of this lady. Now, this is a person who works at Homeland and ICE and removal. His name is Charles. He said, I've held this position since January 26, a newbie, good case to be on in a newbie position. I've been employed by ICE, though, in various capacities since 2008. And I've had a bunch of positions, so I've been doing this a long time, so not a newbie. In my current position, though, I oversee several aspects of immigration and removal. And I oversee strategic planning, and we augment the ICE identification and removal. I'm responsible for a lot of things, including facilitating logistical and operational support in these operations. Now, following the enactment of the Homeland Security Act, ICE was created from several elements of other legacy agencies. We bundled them all together, passed some new rules. We have a docket. We manage a national docket of more than 7.2 million cases. Do you know how many people that is? Which includes non-citizens currently in removal proceedings and those who have already received removal orders and are pending physical removals. Our court docket in this one instance, 7.2 million people. Now, of these 7.2 million alien cases that are managed, approximately 65,000 of them are in detention facilities nationwide. Now, I'm aware the DOJ wants to file an application to remove this lady called Nazera. I provide this declaration based on my knowledge, having reviewed her files in the course of regular business. She was admitted as a lawful permanent resident. She was the spouse of somebody employed over there by the U.S. government. Crazy. So Iraqi and Afghanistan person employed by the government. She's married to this person, comes in during Trump 1. Respondent was a derivative on her spouse's immigrant visa. Respondent's spouse was employed at Bagram Air Base from Afghanistan in 2009 to 16. Comes over here, pledges allegiance to ISIS. So in my review of publicly available information from her son, which we'll look at, he took a guilty plea on November 19, 25, knowingly received and attempted to receive and conspired to receive firearms and ammo and co-conspired with others to support ISIS, a designated foreign terrorist organization in violation of the law, and he's going to prison for 15 years. And so based on a review of these documents, it turns out from August 24 through October 24, Abdullah worked alongside his brother-in-law and other co-conspirator Nasir. They got firearms specifically to commit terrorism. Specifically, they got 2 AK-47 rifles, 500 rounds of ammunition, and they were going to attack the election November 24 of this last cycle. So my review of their files revealed no other criminal history. Other files are unclassified, and I've submitted the classified stuff through the portal. Because she was admitted as a lawful permanent resident, we're not permitted to use classified information ex parte, and some of this is classified. So I've reviewed the FBI's materials as well. All that being said, I believe there is probable cause to establish that she is an alien, and I've established that she also is an alien terrorist as required under the law. And so therefore, I believe that she is an alien, and I also believe she meets the definition of alien terrorist signed by Charles Beavers, and therefore she should be removed and do it quickly. So all of that now submitted, not a ton of details there, but her son is right here. U.S. versus Zada, and he had been prosecuted some time ago, April 17th, charged, case entered some litigation, but then took a plea deal basically the same day. So charged, plea deal, waived the indictment, some sentencing memos came in, and ultimately the sentence was 180 months, no supervised release, and so they're connecting him to her. Here's the petition to enter the guilty plea, bunch of materials here signed, he's waiving his rights, all standard change of plea stuff, but the big, I think, insight comes from the sentencing memo. This is from the government. They say this is what this dude did. He pled guilty to 1 count of conspiring to receive a firearm to commit terrorism. And he admits that he did this. His goal was, quote, to attack innocent civilians on election day at an unknown location. Now, he goes to great lengths to distance himself from the conduct. He even teeters on demonstrating a lack of acceptance of responsibility. He says he was just following his co-conspirator, Nazera. Now, he would have this court believe that he blindly followed this person without any knowledge, but that's just not true. He falsely claims to have no extremist propaganda on his devices, but they do. It contains 2 images displaying the Tawhid finger in messages to his sister. Now, the Tawhid finger is used outside of ISIS, but as noted in the sentencing memo, it's the hallmark of ISIS militants. They use the gesture to signify oneness of God in Islam. He acknowledges that other radical material and others would indicate extremist intent. He overlooks that at the change of the plea. And he admitted he wanted to kill others on election day, literally on behalf of ISIS. Additionally, the FBI located a screenshot of a YouTube video that they were sending to each other. And this channel was where they shared sermons of ISIS. Now, that is the same person, although a different image, that they sent to a sister in a group chat that he agrees is an extremist image. There are also 2 searches for ISIS in his search history. It's clear that these are 2 unique searches because one instance of ISIS is in all caps, the other is in lowercase. This is just part of the evidence against him, but that is his own standard about whether there is extremist material, and he's saying, yeah. So he attempts to say, it's not me, it's that other guy, where the evidence is clear. That guy is clearly a radical Islamic jihadist with allegiance and motivations on behalf of ISIS. But Tawhidi's allegiance to ISIS is already well known, not even in dispute. Mr. Haji Zada does not dispute that by the time he purchased the AK from an undercover FBI agent, he had already known about the planned terrorist attack on election day. He deflects to the other guy. He says, well, he's a bigger terrorist than me. Now, it makes sense that every terrorist becomes radicalized by someone else. People are not born with preconceived notions of hate and desire to do others harm. And that he was able to recruit him and convince him to participate doesn't alleviate him of any culpability. And he's already gotten a better plea deal than the other guy anyways. Now, they cite to a report from a doctor, but he never spoke. The doctor never spoke with this person. And although the analysis, the path to de-radicalization relies on an honest question of how they got involved in the extremism. The report says that this guy portrays himself who, as someone due to age, shows compliance with another instruction. But that's not what we're seeing here. He took his own role in all of this. He raised money. He filed false insurance claims. He was translating for people. He was doing research online. He assisted in the obtaining of a passport. He bought plane tickets. He got money for the AK. But his mindset can also be demonstrated in his interview. During the interview, he denied even the most basic information. He claims not to speak Dari even after being confronted with Dari messages on his phone. He denies knowing what ISIS is, but he does. He says, oh, the AKs were just for recreation. And during his interview, he claimed the 2 AKs were for recreational use. Then he eventually admitted, no, those were for terrorism. He denied that his brother in France knew anything about what was happening. Documents later showed his brother did know. They said, go to a soccer stadium and a shopping center. Those are good places to shoot. His brother was arrested temporarily in 24. And then they sent messages saying, erase everything you have in your phone. I'm cleaning your house. Don't use Telegram. And so both of these 2 were working together. Now, near the end of the interview with the FBI, agents separately brought the father and others to see Haji. Both men encouraged Haji to tell the truth. Then he refused to tell the truth. He said, no, they're target practice. That's all I wanted. His refusal to comply with his father and his other Tawhidi's directive contradicts the narrative that he was just subservient. Okay, he was acting on his own. He wasn't following their instructions. And so after his failed attempt to convince him to be truthful, Tawhidi said, whatever I've told you about him is true, saying, yep, he did actually have a role in this. But the court must review the evidence in the totality. His admission, he agreed to do this, and all of the other benign explanations will fall away compared to those. He claims not to have extremist ISIS propaganda on his devices, but even if he does, he was young, and he was just following his family. But you got to consider the nature and the characteristics of him. We asked the court to give him the serious sentence that we recommended below. And in the wake of all mass murders, it is not only common, but natural to ask, why did this happen? How did somebody get to this point? But whether it's ideological or influence of others or more, doesn't matter. This dude agreed to commit a terrorist attack. He wanted to kill as many people as possible. And so you should sentence him at the top of the range, signed here by the DOJ. And now Mama has been identified too. So they've got her currently in custody. They are scheduled for a hearing literally today. We'll see what the outcome of that is. But the case, 11 a.m., July 30th, everyone's there just for an initial proceeding, one initial hearing about the application. And so this signed off on by this judge in one of the, an unprecedented case. This has never happened before. First one ever out of this court, Chief Judge Honorable Joan N. Erickson. And so we'll see what the court says and whether this is sufficient. But as we talked about when we read through the various rules that govern this court under U.S. Code, we saw the standards are very, very low here. Okay, that's like preponderance of the evidence, more likely than not, and you're gone. So this will be a very interesting case to watch and develop to see who else will qualify in this court, what the procedures look like, how quickly we can expedite people through, and get terrorists out of our country who we brought in here apparently in good faith. Oh, you worked over there. You helped us bring them in. Fast forward a couple of years, they support ISIS. Didn't assimilate at all, did they? So maybe it's a good indicator on what immigration policy should be. So big update on this one. Once more stuff drops, we'll hit the highlights and see exactly what else is going on here. But for now, at least we've got another terrorist family off the streets. All right. And so good update on that one. And then now, my friends, we've got some Tyler Robinson prosecution stuff that also dropped today. And so let's take a look at what was filed in this case right now. Prosecutors now file their brief arguing that there is clearly probable cause in the prosecution of Tyler Robinson, saying the case must be bound over from this status, put on a full path to trial where litigation will continue. New evidence will ultimately come out. We'll get expert witnesses validated and more. But they say we've met the low burden right now at this time. It's only probable cause. And based on what we presented and based on what the defense presented, you should carry this forward and send this onto the trial track. Now, of course, the defense will file their own brief and their own response. And when they do, we'll go through that as well and give both sides the benefit of the doubt so we can entertain their arguments and then find where the truth lies ultimately at the end. But the case has been developed for a very long time. You can see this is the full docket here. We covered large portions in recaps of the preliminary hearing, which took place over 5 days from 7/6 to 7/10. And now we're getting the briefs that are a compendium of all of the arguments. So all that time gets squeezed into one brief to make the final pitch to the judge that this needs to carry forward on the path to trial. And this document just dropped fresh out of the oven. You can see we do not have the defense brief yet, but we will. And when we get it, we'll review it. But here's what the government is saying. The prosecutors in the state of Utah versus Tyler James Robinson, the alleged Charlie Kirk assassin, may he rest in peace. Here's their memo in support of the bind over. They say, all right, listen, Judge Graff. After taking evidence at the 5-day hearing from July 6th to the 10th, this court, acting as magistrate, asked the parties to send in this brief. And here it is. This is likely as straightforward a bind over decision as this court will ever see. Opening strong. After admitting to several friends, including his roommate and romantic partner, that he assassinated Charlie Kirk at UVU on September 10 in front of approximately 3,000 eyewitnesses, Robinson then surrendered to law enforcement for that very crime. Now, these admissions, along with others, establish probable cause to support most of the elements in the charges, like that alone. The admissions are damning, they say, and so that's enough. But we're also going to add in DNA testing, surveillance video, eyewitness testimony, and those things buttress those other elements and demonstrate probable cause to support the remaining elements of all the various crimes. So you should bind over Robinson for trial on all counts. Here's the facts presented. On September 10, 25, Charlie Kirk and Turning Point were holding an event at UVU, Orem, Utah, and they're referencing the transcripts and the times. Several thousand people attended and filled the amphitheater located near the center of campus and west of the Losi building, sharing more exhibits, referencing the transcripts, representing the exhibits. Now, after the event began, Charlie seated himself under a canopy tent positioned on the west side of the amphitheater below the Hall of Flags. And at approximately 12:28 p.m., an attendee standing directly in front of Charlie was questioning him, the trans question, when a gunshot rang out and a bullet struck the left side of Mr. Kirk's neck, killing him. The bullet's trajectory was front to back, slightly left to right, and downward. So front to back, left to right, and downward into his body. The medical examiner concluded the manner of death to be homicide. A forensic examination conducted by the ATF revealed that the bullet that killed Charlie was a .30 caliber class round. It created a complex entrance gunshot wound and fragmented into Charlie's neck, blew apart. Now, the bullet, or at least parts of it, sequentially perforated the anterior left side of Charlie's neck, strap muscles on the left side of the neck, and the left common carotid and left internal and external jugular veins. So a bullet goes in, fragments out, causes a bunch of damage inside the neck, and they identify it. The bullet also obliterated the left side of the C2 through 7 vertebrae and transected the cervical spinal cord. And many people noticed how Charlie's hand movements looked and how it kind of looked like that had happened. The medical examiner observed that a significant portion of Charlie's cervical spinal cord was traumatically absent. Kirk suffered other severe injuries, including a bilateral apical and posterior intercostal hemorrhages, pulmonary apical hemorrhages and hematomas, and multiple disruptions of the thyroid, cricoid, and tracheal cartilages. So just wrecking everything in the neck. The medical examiner also observed hemorrhaging around Mr. Kirk's heart, both of his lungs, as a hemopericardium and left and right hemothorax, and in the subarachnoid space around the cerebellar, vermis, and parietal regions of Mr. Kirk's brain. Everything inside, all of the mechanics inside your neck and head and heart, this whole region, all just completely devastated. Pronunciation corrections appreciated. Now, when the bullet struck Charlie, Officer Christopher Bagley of the UVU police was stationed on the south end of the walkway roof of the Hall of Flags above Mr. Kirk's canopy. Based on his experience with firearms, Bagley believed that the bullet came from a rifle fired from a position east of Mr. Kirk's canopy. Recognizing that the Losi building was east of the amphitheater, someone on the roof of that building would have a direct line of sight to where Charlie was seated. Bagley quickly made his way to that roof. There, he observed a screwdriver about 10 or 15 feet from the guardrail. He also observed disturbances in the gravel at the southwest edge of the roof that were consistent with a sniper pad, meaning a place where a person was laying in a prone position with a line of sight to where Charlie was seated. Bagley continued and reviewed the surveillance video of the Losi building rooftop. That video shows a male running towards the southwest edge of the roof, then dropping down, crawling and getting into a prone position at that edge of the roof. The video further shows that at about 12:23:28, the moment of the gunshot, that individual quickly stood up, ran northwest across the roof carrying a long, skinny black object, and eventually dropped himself down from the northwest side of the roof down to the ground. That individual crossed Campus Drive, entered the wooden area on the north side of Campus Drive. We saw the videos here. So in that wooded area, police later recovered a rifle wrapped in a black towel. The rifle was an operable Mauser Model 98 .30-06 Springfield caliber rifle. A telescopic sight was mounted to the rifle. Investigators reviewed hundreds of hours of UVU surveillance footage video to track forwards and backwards the person that was seen on the Losi building roof at the time of the shooting. After Robinson turned himself in, investigators also reviewed the footage, searching for someone matching defendant's description and driving his car. Now, those efforts revealed that a vehicle registered to Robinson arrived at the campus the morning of the shooting. The video also shows an individual believed to be Robinson walking around the campus that morning, going to the railing on the roof of the Losi building, and then leaving. Investigators ultimately determined that Robinson visited the campus at least 4 times on September 10 and 11, 25, twice before the shooting, a third time just before noon on the 10th, and a fourth time in the early hours of September 11, 26. Footage also shows that when Robinson returned to campus just before noon on the 10th, he was wearing different clothing, but his shoes were the same. Also walking with a limp. Roommate and romantic partner called Lance Twiggs confirmed that still images taken from that portion of the surveillance video that show front views of the individual's face, quote, definitely did, quote, look like defendant. And he kind of also said, he kind of hesitated there at first during that exchange. He said, well, I'm not sure. Okay, that definitely does look like him. And so the defense will say, yeah, but he wasn't sure. And the defense will say, you only started to identify him once he turned himself in. Okay, after he turned himself in, then you filled in the gaps. Then you start looking for him. And so now you're creating this chain. But their argument will be, once he turned himself in, you stop looking for anybody else. There's an absence of evidence. You should have continued to try to identify other people. So what if he was there? You then eliminated our opportunity to identify exculpatory evidence and find another prospective shooter, is going to be, I think, what they'll argue. But then Lance says it definitely did look like defendant, and so it's him. Now, given their extensive review of the footage, investigators concluded that Robinson was in fact the individual who was walking with a limp up the stairs that accessed the roof shortly before noon, who was on the roof at the time of the shooting, and who dropped off the roof and then made his way to the wooded area where the rifle was found. Then on September 11th at 12:36 a.m., he returned to the intersection of the campus at 800 South on UVU. He attempted to turn south on Campus Drive, but was turned away by an officer stationed at the intersection. Campus Drive leads to the wooded area where the rifle was found in the bushes, so he's going back to pick up the weapon. DNA testing of the screwdriver recovered from the roof and the towel wrapped around the rifle provided, quote, very strong support for including Robinson as having contributed DNA to those items. States Exhibit 31. DNA testing on the rifle trigger, the trigger guard, grips, protected underside of the receiver, and other parts as well as the fired cartridge casing in the rifle also supported Robinson as having contributed DNA samples recovered from those items and areas. So DNA all over the gun and DNA on the towel and more. Now, on the evening of September 11, 25, defendant Robinson surrendered himself to law enforcement in connection with Kirk's assassination. Also admitted to Lance Twiggs, the lover, and other friends that he had shot Mr. Kirk. The state charged him with these following crimes. Count 1, aggravated murder. Count 2, felony discharge. Count 3 and 4, obstruction. And those are specifically for, obviously, murder of Charlie, felony discharge, serious bodily injury. We've got obstruction for concealing and removing the firearm, and for destroying, concealing, and removing the clothing. Clothing's gone. Tampering with a witness, counts 5 and 6. Directing Lance Twiggs to delete their messages and to refuse to speak to law enforcement. So telling Lance, don't cooperate, don't out me, which really makes Lance, kind of a co-conspirator in a way for concealing a wanted fugitive, which the defense is going to latch onto. And so, just to kind of give both sides their shake, the defense will come out and say anything that Lance Twiggs says or did is going to be completely biased and unreliable. Count 7, violent offense committed in the presence of a child, and victim enhancement for the targeting. So the state also notified Robinson that counts 1 and 2 were subject to sentencing enhancements, and we'll come back to that. Now, those are the facts, Judge. So as magistrate, this court has one duty left. You have to determine whether the evidence admitted at the preliminary hearing supports probable cause, which is low. Probable cause to believe that the crimes charged in the information have been committed and that the defendant committed them. That's it. This isn't a close case, they say. Now, the state presented more than enough evidence to support probable cause on all 7 charges, and let's go through them. The first section here is going to be about what probable cause actually means. Now, at this stage, the state must demonstrate only probable cause, which is simply a reasonable belief that a crime was committed and that this guy Robinson committed it. In determining whether the state has surmounted this low bar, the court must view all evidence and all reasonable inferences in a light most favorable to the state, not to Robinson. Now, the purpose of the hearing is not to determine guilt or innocence, and we haven't heard really many of any Robinson's defenses at all. Is he like factually innocent? Was he not there? Does he have an alibi? Is there, there could be a lot that comes out. But that's not what we're talking about right now. It's only based on the evidence here. Is it reasonable to believe that there was a crime committed, obviously, and this guy committed it? They say its purpose is limited to ferreting out groundless and other improvident prosecutions and spare defendants from the whole trial process. Is there enough to even hold this dude? Because we're going to be on this for maybe another 2 years. So before we, have a 3-year criminal prosecution, let's make sure that there's sufficiency to do that. So the hearing is a constitutional safeguard against unwarranted prosecution where it appears manifestly that no crime was committed or that the accusation against this prisoner is wholly groundless. And under the Constitution in Utah, a line separating a valid prosecution from a groundless prosecution is probable cause. It's in the Constitution. If the evidence supports probable cause that the crime charged has been committed and that this guy did it, you have to order them to be bound over. It's must. And it's a low bar. It doesn't require proof beyond a reasonable doubt. It's lower than a preponderance of the evidence standard, even in civil cases. Thus, a showing does not even require elimination of alternative inferences in favor of the defense. All that's required, sufficient evidence to support a reasonable belief that this guy did it. Now, it's groundless only if the evidence presented fails to establish cause. That means the evidence has to be wholly lacking or incapable of supporting a reasonable belief that he did it. Put another way, you may decline to bind this over only where the facts presented provide no more than a basis for speculation. And now at the hearing, you must view all evidence in a light most favorable to us, they say. The judge only has a limited role in judging the credibility of evidence. You may disregard or discount evidence only if it's contradictory or inconsistent or unbelievable to the extent that it would lead to an unreasonable to base a belief on that. Otherwise, you may not accept the defendant's version of the events. Now, we introduced a bunch of evidence. Okay, that's the standard. It's probable cause, very low, and generally easy to achieve. Now, in this case, the state presented, quote, more than enough evidence to sail safely over this on all 7 charges. First charge, aggravated murder. We got to show that this person, the defendant, intentionally or knowingly caused the death of Charlie under circumstances knowingly creating a risk of death to another individual, like shooting them. The evidence supports that. Okay, as to death, no one is disputing this. Maybe some people are. That Kirk was killed on September 10th by a gunshot wound to the neck. We all saw it. May he rest in peace. Also, as to identity, how do you show that it was Robinson? Well, they say he admitted it. He said multiple times that he did it. He shot him using his grandfather's rifle. They give us all of their exhibits that they presented at the prelim. 16.3, quote, I had the opportunity to take out Charlie Kirk and I took it. Next one, I am the one who did it. I'm sorry. Why did I do it? He asks. I had enough of his hatred. Some hate can't be negotiated out. Now, if I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again, which corroborates the stop or the location where he was on the road going back to the drop point. Hopefully they have moved on. I haven't seen anything in the news about them finding it. Next one, I've been planning this, and they're kind of, summarizing here. So those are not exactly verbatim, but how long have I been planning it? A bit over a week, I believe. Then he says, I'm wishing I had circled back and grabbed it as soon as I got to my vehicle because it sounds like the police couldn't get in for a long while because of this traffic. Now, remember how I was engraving bullets? The effing messages are mostly a big meme. If I see notices bulge with the eye emoji, UWU, on Fox News, I might have a stroke. Goes on. Judging from today, I'd say grandpa's gun does just fine. I don't know. I'm going to turn myself in willingly. He says, hey guys, I have bad news for you all. I think this is in the Discord. It was me at UVU yesterday. I'm sorry for all of this. I'm surrendering through a sheriff friend in a few moments. Then says again, it was me. Look at the pictures from the surveillance footage. It was me. I'm serious. Because in Discord, they were saying, no way, like, you're not serious. Like you're making this up. Like I'm panicking. He said, it was me. Look at the footage. Now, the defense, they're either going to have to admit this and explain it away. Like they say, yeah, he did send these messages, but they were false messages. They got his phone. They got search warrants for the phone. They imaged everything. They'll be able, I would presume, to geolocate where he was and track the movement of the phone, just like they did with Kohberger and others, and follow him through this. Somebody, they may argue, had his phone and was sending these messages, so he didn't actually send the phone. Somebody was maybe spoofing the phone. They may say that. Otherwise, these are admissions. And just because you have admissions doesn't mean that you have the body of a crime, right? You don't have the corpus of the crime. So people sometimes admit to things all the time, like they're crazy people. Like, I shot JFK. Crazy guy walks into the police station. I shot JFK. You're like, you're 25 years old. Clearly you didn't do that. So just, an admission alone is not sufficient, but when you have other evidence, the corpus, the body of the crime to back up the admission and to corroborate it, then those admissions are very damaging once they're validated as omissions. So how does the defense get around these? They say he sent them, but they're not true. He's taken the fall from someone else, so he physically did send them. They were on his phone. The evidence connects the phone to the messages, and he did it. Or somebody else had the phone and was sending the messages, and he didn't do it. And then, of course, you got to explain that and how that ultimately happened. So we'll see. But that's what they're submitting to the judge. Then he surrendered. Okay, so if he's not sending the messages, if he's not actually the person sending them, then why did he go and self-surrender? Is he taking the fall for somebody else? Because the self-surrender, which is a physical person doing that, would be consistent with his admissions in the messages. So he does that. Surrenders in connection with the shooting. DNA testing supports the conclusion that he contributed the DNA samples to the fired cartridge, the trigger, other parts of the rifle, the towel used to conceal the rifle, and even the screwdriver that was recovered from the top of the roof. The car was also on campus on September 10 and 11. Not only did the defendant admit that he was the one depicted in the screen captures of the surveillance footage, he also and his roommate and romantic partner confirmed that the individual in those screen captures, showing the individual's full face, definitely looked like him. So now you've got Lance Twiggs corroborating it. Again, the defense is going to come back out and say that it's not a certain ID, right? The defense will say he was kind of wishy-washy about it, and maybe he's trying to get an immunity deal so he doesn't get prosecuted for his greater involvement in this, and that Lance is unreliable because of that. And so anything that he says, including this ID, is invalid. Just putting the other hat on to argue what they're going to say. Element 2, the state's evidence also demonstrates that he intentionally or knowingly caused Kirk's death. A person acts intentionally with respect to a result of his conduct if he has a conscious desire to do the thing. Okay, he knowingly does it when he's reasonably certain that he'll cause the results. Now, a mental state is rarely susceptible to direct proof. How do you go into somebody's brain and extract out a thought and then introduce that thought as evidence? But this case is exceptional because, as shown above, he admitted it many times that he intended to cause Charlie's death by shooting him with a high-powered rifle. He wrote to Lance that he had the opportunity to take out Charlie, and he took it. He also texted Twiggs that he had been planning this for over a week and that he killed him. Why? Because he had, quote, enough of his hatred. Now, he also engraved the bullets that he loaded into the .30-06 caliber rifle. He also took some target practice before shooting and engraved one cartridge found at his home with the words, "test shot." And the circumstances of the shooting itself, when properly viewed in a light most favorable to the government, further demonstrates that he intended to cause his death. He went and surveilled the campus, then changed his clothes, then returned back with the rifle. He used a screwdriver to assemble the rifle on the building's rooftop. When the rifle was loaded, With 4 engraved cartridges, Robinson then crawled to a sniper perch on the edge of the roof, took aim at Charlie, and pulled the trigger. The evidence overwhelmingly demonstrates that he acted with the required mental state and in conformity with the admissions. Surveillance corroborates it. The DNA corroborates it. You see the test shots, right, and the engravings on the test shot corroborate that was found back in his home, corroborates the engravings on the bullets there. You've got the vehicle surveillance, vehicle location. All right, so the state's evidence also, when properly viewed, also demonstrates a reasonable belief that the defendant knowingly created a great risk of death to another. He fired a high-powered rifle toward a crowd of thousands, creating a great risk of death to anyone who is in the line of fire or who is even near Charlie. Now, what does that mean? Great risk of death as an aggravator. In Utah, the Supreme Court there said that this aggravating circumstance is met where another person is placed within the zone of danger. And in order to consider that, you need to look at the temporal relationship. You need to look at the spatial relationship. So how close in time was the act and how close was that act to other people in the vicinity? Spatial relationship, how far away? Whether and to what extent the third party was actually threatened by the assailant, other people in the crowd. So applying these factors, there is a zone of danger here and a reasonable belief that he put them in it. Most significantly, everyone in Robinson's line of fire was within the danger zone. The person questioning Kirk was clearly within the line of fire. The questioner was just a few feet in front of Charlie and directly between the sniper and the Losi building roof. Thus, the spatial relationship between the questioner and Kirk put the questioner in the zone of danger, which aggravates this. The questioner's proximity and placement relative to Charlie also created an indirect threat to the questioner because there could have been a stray or ricocheting bullet. Same factors would apply to anyone else who's directly behind the questioner and also within the line of fire. Now, the evidence also shows that Robinson was not certain to hit only his target, Charlie. He loaded the rifle with 4 cartridges, creating a reasonable inference that he anticipated he might miss on the first shot. Moreover, the evidence of his target practice before the shooting shows he did not always hit the bullseye. Some of his shots completely missed the paper target. And even if the defendant Robinson had previously calibrated his rifle and scope, he had disassembled the rifle to transport it to the roof undetected and then reassembled it on the roof using the screwdriver that he had left there, so it's out of calibration. One reasonable inference from these facts is that the reassembled rifle would not be as accurate as it previously was when it was sighted in while in one piece. So a defendant who shoots another person knowingly creates a risk of death to anyone in the line of fire. Pennsylvania Supreme Court found that same thing in a case called Watson, where while shooting his ex-girlfriend, the child was in the closet. Okay, that's a great risk of death to the child. Another case called Commonwealth versus Reed, 12 to 14 other people were in the line of fire on that one. Another one called Buck, saying that evidence that the defendant fired a single fatal shot at his victim while another person was in the line of fire could support a finding that there was a grave risk of death to another. Another one out of Arizona, and we get the point. Now, the evidence demonstrates that Robinson here knowingly created a great risk of death to the questioner and all of the others who were in the line. The distance from the sniper perch to the tent where Charlie was seating was approximately 410 feet with 68-foot vertical drop. 410 feet is less than the 415-foot distance from home plate to the center field at Coors Field in Denver, and approximately 137 yards, which is just longer than an American football field, which includes the 2 end zones. From Robinson's perch, he could see the questioner and those directly behind him, so he knows there are other people there and presumably even hear the questioner because the speakers have been set up to amplify the discussion. So Robinson could certainly see the individuals through the scope, and therefore he was aware of these circumstances. He knew these people existed, these people were in the line of fire, and he fired the shot knowing that. So therefore, that is aggravating. Now, he also knowingly created a great risk of death to all others who were near Kirk, but not even in the line of fire. Another case called Sosa Hurtado says the firing of a gun at one person can create a great risk of death to others who are near, even if they're not in the line. This case, called Sosa, involved a murder in a small smoke shop where a father and son worked. After Sosa repeatedly refused his father's demands to move the car because it was endangering customers, the son intervened and again asked Sosa to move the car. Sosa responded by punching the son and starting a fist fight that Sosa Hurtado ultimately lost. Sosa then left, but later returned with an assault rifle, fired one shot at the father, who was standing behind the counter 2 to 4 feet from his son. First shot missed the father, hit a glass case, sending glass and wood into the father's leg. Father got hit with glass. Then Sosa returns towards the son, fires a second shot, hits the son in the hand. He falls over. Father began to get up and move towards the son with his back to the father. Sosa leans over the counter and then shot him twice, killing him. So the smoke shop consisted of a single room, 15 feet wide, 24 feet long. Brutal. After a jury convicted Sosa of aggravated murder, he appealed on the sufficiency of the evidence. He says, "I didn't create a great risk of death to anyone else when I killed that guy." Utah said, "Yeah, you did." They rejected his argument and said it is aggravated murder, which enables the death penalty. Now, the court found that 2 separate acts each created a risk of death. The first shot towards him. The second was the initial shot aimed at the son, a shot that hit the son in the hand when the father was only a few feet away. The court said that a reasonable jury could conclude that both acts created a great risk of harm to another. So firing at one person while another was only a few feet away does knowingly create a great risk of death for that other person. They're saying it's the same here. In addition to those in Robinson's line of fire, several others were in close proximity to Charlie when he was shot and killed. At least 2 individuals were standing under the tent where Charlie was seated. Others were near the front, sides, and back of the tent. And as in Sosa, these individuals and their proximity to Charlie put them in a zone of danger. Their proximity and spatial relationship, together with indirect threats to them arising from the risk of a stray or ricocheting bullet or exit wound, put them in the zone of danger, especially where defendant used a high-powered rifle to kill Charlie. Other courts agree. Stray, ricocheting, or there you go, pass-through bullets create a zone of danger for anyone close to the victim. Supreme Court in Pennsylvania and Commonwealth versus Rio said the same thing. Firing of a fatal bullet at the victim while the victim lay on the floor of an enclosed bedroom while another floor close to the bedroom or on a bed nearby meant that there was a danger to everyone in that bedroom. Bullet could have gone through and killed them. So the risk of death was not reduced only because this person fired a single round. It is not necessary that the endangered bystander be directly in the line of sight. And so they're really attacking this element from both angles. Okay, it's the people ahead of the bullet, in the line, it's people out of the line. So if you find one is invalid, you still got to back up on the other one to keep this aggravated. Indeed, the Pennsylvania Supreme Court has also confirmed this conclusion. And of course, this is Utah, it's not Pennsylvania, but probably not a lot of cases that are exactly on point. So they go out to Pennsylvania. They're saying this is persuasive law. They say the zone of danger encompasses everyone near the shooting victim. In a day and age where accidental victims of shootings are prosaic, a jury can infer that an individual is knowingly endangering a person when they use a gun in any area where they know others could be. In another case, Commonwealth versus Smith, jury properly found that the defendant created a grave risk of death where others were in danger of being struck by an errant, ricochet, or pass-through bullet. Now, as with those in the line of fire, prosecutors say Robinson also acted knowingly in creating a grave risk of death for all those close to Charlie when he pulled the trigger. Again, he could see, especially through the scope, those who were in front of and to the sides of Charlie. It is also reasonable to infer that Robinson could see people behind the area of Kirk's tent. In fact, earlier that morning, Robinson had been down to the amphitheater area, interacted with some TPUSA representatives, and would have seen firsthand the staging area behind Charlie's tent. So he was thus aware of the existing circumstances, that is, that several people were near Charlie when Robinson shot him. And again, the defendant himself anticipated that he might miss Charlie. He loaded his grandpa's rifle with not just one engraved bullet, but with 4 engraved bullets. Had he been certain of his aim, he would have no reason to load it with more than 1 bullet. But he was well aware that he might miss his target and put others in danger. But those in the line of fire and others nearby could have been in the zone. and he thus came prepared with 4 bullets in the event his aim was not true, a real possibility that his target practice had confirmed to him. The state therefore presented ample evidence of this aggravating circumstance, and because this evidence demonstrates probable cause for each of the elements, count 1, aggravated murder, the aggravated murder charge must bind the defendant over for trial on that count alone. Now count 2. Felony discharge of a firearm. Again, Robinson discharged a firearm in the direction of an individual, knowing or having reason to believe that an individual may be endangered and caused serious bodily injury to that person. Same evidence that establishes probable cause up above does the same here. As explained, the evidence establishes probable cause that Robinson fired a high-powered rifle in Charlie's direction, and as explained, it establishes that defendant knew that firing a rifle would endanger Charlie because he admitted he intended to kill him. So the evidence also establishes cause that he inflicted serious bodily injury. Bodily injury is permanent disfigurement, protracted loss, impairment of function, or substantial risk of death. He did not merely cause a substantial risk of death, he killed him. And so that also is met, and so we think there's probable causes to count 2. Count 3 and 4, obstruction. Now, to establish that he committed obstruction, he concealed the firearm and eliminated the clothing. They got to show he, again, with intent to hinder the investigation, destroyed or concealed evidence. Now, the evidence does establish probable cause, say the prosecutors. He admitted to Lance Twiggs that he had concealed his rifle. He said it in a text. I put it in a bush where I changed outfits. Surveillance video also shows Robinson moving both towards and away from the wooded areas north of campus where investigators found the rifle. And as for his clothing, consistent with his admissions to Lance, the surveillance footage showed Robinson returning to campus just before the shooting, wearing different clothing than what he wore during the previous visits. He also admitted to Michael Mitchell that he discarded the clothes that he wore during the incident. Michael Mitchell now got that admission. I eliminated my clothes. So all this evidence establishes a reasonable belief that he removed and concealed the rifle that he used to shoot Charlie, destroyed and concealed the clothing that he wore during the firing of the fatal shot. So that, again, establishes probable cause as to obstruction. Now, the evidence also establishes cause that he wanted to hinder and prevent the investigation. Robinson texted Twiggs that, quote, he had hoped to keep his secret till he died of old age, and that if he were able to grab his rifle unseen, he will have left no evidence. In the note that Robinson left for Twiggs before driving to the campus under the keyboard, he predicted that by the time Twiggs read the note, he would, quote, likely be dead or facing a lengthy prison sentence. These admissions demonstrate that Robinson knew a criminal investigation for murder would follow the shooting of Charlie and that he intended to obstruct the investigation. And at the very least, that is a reasonable inference from his admissions. The evidence, therefore, again, establishes probable cause that he did obstruct justice as to both counts. Now, the evidence as to subsection D, counts 5 and 6, tampering with a witness. In order to prove that, we've got to show he, Robinson, believed that an official proceeding or investigation was pending, wanted to prevent the investigation, and attempted to induce others to withhold information relevant to that investigation. They say all of this is supported. After Robinson made several incriminating admissions during a text exchange with Twiggs, some of which are described above, Robinson directed Twiggs to, quote, delete this exchange and to, quote, not speak with police. He demanded that Twiggs delete the messages. That establishes probable cause for the first and third elements, which are here. He did it and wanted to withhold testimony or information, inducing another person to do that. His demand that Twiggs not speak to the police establishes probable cause for the same elements of count 6. And so the evidence also establishes probable cause for the second elements of both counts. He either believed an investigation was pending or intended to prevent an investigation, as they've explained. In the note that he left for Twiggs before driving to UVU, he predicted that by the time Twiggs read the note, he would, quote, likely be dead or facing a lengthy prison sentence. He also explained, as we explain, Robinson texted Twiggs that he had hoped to keep this secret till he died of old age, and that if he is able to grab his rifle unseen, he will have left no evidence. When Twiggs stated that he thought police had, quote, caught the person, Robinson clarified that police had grabbed some crazy old dude and interrogated someone in similar clothing. So it's not him, it's me. He also explained that police activity, including an officer with a canine, was preventing him from going and getting his rifle back. It was after these additional admissions that then Robinson directed Twiggs to delete their text, "Don't speak to anybody," including the police. The evidence therefore establishes probable cause that he knew an investigation was underway. He gave those directions to Twiggs, and there's probable cause for both counts of witness tampering. Then we've got violent offense committed in the presence of a child, committed homicide in the physical presence of a child 14 years or younger, knowing the child was present, and that he targeted Charlie because of his political expressions. Similarly here, probable cause exists. They say, as explained, evidence establishes definitely the first two elements, and also that there was a 14-year-old child, somebody younger than that, who was present there. A video from a mother in the crowd shows that she was there with her children, at least one of which was under 14. Another shot from behind Charlie shows two women in the crowd holding infants. The two women are standing next to each other and can be seen to the right of the speaker's pole that is visible in the right center of the frame. So therefore, we meet that element. Also showing that he knew this. He could see the entire crowd from the rooftop. He made 2 visits to the campus and to the amphitheater, walked down below, and even got lunch at the Sorensen Center, which borders the amphitheater. So one reasonable inference from walking around that area is that he would have seen all of the people who were gathering, including the children who were present. So reasonable to show there's probable cause as to count 7. Also establishes cause because he targeted Charlie on perception of his political expression for Charlie's politics. The victim targeting penalty enhancement enhances the crime of committing a violent offense in the presence of a child from a misdemeanor Class B to a Class A if you intentionally chose the victim and you did it because of a personal attribute. This case, Charlie, is political expressions. The evidence also says that this is all supported. Robinson admitted to Twiggs that he, quote, had enough of Charlie's hatred. Some hate can't be negotiated out. He also wrote to Twiggs that they wish that they could have lived in a world where this did not feel necessary. In his message, he did not identify what he believed to be the specific hatred from Kirk that he needed to stop by killing him, but that's not necessary to prove intent beyond a reasonable doubt, much less to establish probable cause. Specific intent may be proved by circumstantial as well as direct evidence. So, in other words, he didn't need to say, I hated him because Charlie spoke out about the trans. You can use other evidence to confirm that. Circumstantial evidence is overwhelming. The defense would want the court to believe that he was only a religious evangelist, but he wasn't. He was much more. He was the founder, CEO, board president of TPUSA. Their express purpose is, quote, to empower informed civic and cultural engagement, grounded in American exceptionalism and a positive spirit of action. As the leader of TPUSA, Charlie helped citizens develop the knowledge, skills, and values and motivation so they can meaningfully engage in their communities to restore traditional American values like patriotism, respect for life, liberty, family, and fiscal responsibility. And to that end, Charlie would hold events like the one at UVU to engage in civil debate, they put in italics, and to persuade attendees to follow a mindset rooted in politically conservative values, to talk about political doctrines. Those traditional American values, in Kirk's view, are synonymous with the classical Orthodox Christian positions on marriage, family, gender, and sexual being. Charlie believed, quote, that God determines whether a person is male or female, true, and that experimentation with sexual gender identity is sinful and therefore should not be engaged in, accepted in culture, or allowed under the law, and that heterosexuality inside the confines of marriage is the only virtuous pattern for sexuality. So the evidence shows that Charlie represented not only a religious movement, but also a political movement against gay marriage and the accommodation and acceptance of transgenderism, homosexuality, and sexual experimentation. Now compare that with Robinson. Robinson's lifestyle, on the other hand, stood in sharp contrast to Charlie's religious and political views. The evidence shows that Robinson was in a homosexual relationship with Lance Twiggs. The evidence also establishes that at or near the time of Charlie's assassination, Twiggs was exploring transitioning from a man to a woman. And Robinson's texts to Twiggs demonstrate that he loved and cared deeply for Mr. Twiggs. And so, in other words, Robinson's beliefs and practices pertaining to gender and sexuality were directly contrary to Charlie's political and religious beliefs and practices. And so, against that backdrop, the evidence establishes that Robinson engraved the cartridges with his political messages. The spent 30-06 cartridge was inscribed with the words "Notice his bulge, OWO," a furry meme and reference to male genitals, the bulge. One of the unspent cartridges found in the grandfather rifle contained an inscription referencing homosexuality. If you read this, you are gay. And another unspent cartridge contained an overt political reference to "Hey fascist, catch." So the evidence supports a strong and eminently reasonable inference that defendants targeted Mr. Kirk because of his belief or perception in his political expression. And so that means count 7 should be enhanced up into a Class A misdemeanor. So the court needs to bind this over. It does not need to bind over on the sentencing enhancements that do not increase the level of the offense. But even if the court did, the evidence demonstrates probable cause for those things. So we can add those later. The enhancements, the aggravators, you can add all of that later. You don't need to do that now, but you should, and you can. The state already notified them that the sentencing enhancements for committing a violent offense in the presence of a child, targeting because of political expression, does apply to counts 1 and 2. You don't need to bind these over now because they don't increase the level of offense, and therefore they're not elements of the underlying offense. Only reflection of them is in the sentence if he is convicted. And so we only need to establish probable cause as to the elements of the charged offense, not to the sentencing enhancements. We can get to those later. But even if we were required to demonstrate probable cause to those, we've already done that as we just articulated here. Now, hearings like this are concerned only with the elements of the charged crimes. So to prevail here, we only need to produce evidence of all of the elements of the crimes charged, not necessarily the enhancements. They do not increase the level of the offense. Supreme Court in Utah has expressly recognized that enhancements don't need to be formally charged. And in his murder prosecution for shooting his grandfather in another case called Schroeder, they said the state did need to charge those things. But the Utah Supreme Court rejected that, explaining that only elements of the crime need to be analyzed for bind over and not all of the elements of the punishment relevant to the sentencing. So the punishment for a crime is not and has never been considered part of the pleading. After the conviction, we'll go through a separate process to determine these enhancements. All we got to do is notify them of the sentencing enhancement, and the prosecution does not need to charge that formally. And as in another case, Angus, the court explained the information that charged a crime that could have a firearm enhancement would be sufficient if it alleges either it's being charged under an enhancement statute or that a firearm was used in the commission of the offense charged. And so in these other cases, they expressly rejected these other things. And so accordingly, we're not required to prove these right now. And the court is not required to bind the defendant over on the 2 sentencing enhancements as they relate to count 1 and 2. And so regardless, the evidence demonstrates probable cause to support the enhancements either way. So even if the state were required to demonstrate probable cause as to both sentencing enhancements, it did. The evidence established probable cause to satisfy victim targeting and presence of a child there. And so for these reasons, you should bind Tyler Robinson over for trial on all counts as charged in the information. And so that's from the prosecution. And as we saw, I think it's a very substantive case that they're presenting. It's a low standard. We've heard virtually no defense from the defense on how they're going to attack each one of these elements. But in other contexts, in other arenas, in other states, you could do a probable cause hearing on a murder case like this in a matter of hours. We got 5 days and we've got multiple briefs that will be submitted. But admissions plus surveillance footage is probably enough in many other locations because the standard is so low to establish probable cause to bind this person over. Now, the defense will come out, and I'm very curious to see what their brief looks like. There's, I think, going to be an attack on all of the various allegations here piecemeal. I don't know if they're going to argue factual innocence, like Tyler Robinson was not the shooter. Tyler Robinson was not there. He has an alibi. He was in a different location. It wasn't a 30-06. It was an exploding microphone, or what their arguments will ultimately be. But even at this stage, we may not see a lot of that. We may just see them want to go through this and try to say why each one of these components is not reliable. Okay. In other words, the admissions don't prove the crime. DNA evidence can be explained because it was his gun and he did do target practice, but he didn't shoot the gun on that date and time. Surveillance footage wasn't him. Okay. Like, just go through each one of these elements to say our interpretation of your pillars of your case are not sufficient for probable cause without them offering an alternative explanation. Of course, it's not their requirement to do that right now. In fact, they don't have to present any evidence. They can just say that it is insufficient as has been presented now. But ultimately, as we saw, any inferences in this proceeding are viewed in an inference in a light most favorable to the prosecution. And I still think that there is going to be just gobs of additional evidence that come out on this, mostly related to some of the technical stuff, vehicle location data, cell phone location data, a lot more surveillance footage. I know that Candace Owens released another very blurry piece of video that a lot of people are analyzing. I saw it. I didn't see much in there, but a lot of activity that will continue on. And of course, we want justice in this case. We certainly want the person who shot and killed Charlie Kirk to be held accountable. We don't want an innocent person to go to prison for something that they didn't do, so the real shooter goes free. And so we're in the middle of a process where iron sharpens iron. Both sides will make their case. We presume that Tyler Robinson has a defense team that has access to evidence, and if they have an alibi, if they have some way to evaporate the actual caliber of the bullet, the 30-06, they'll pull on those strings and make their case when it is time to do so. But at this moment, where it stands right now, certainly looks like they've got DNA evidence, they've got multiple admissions, they've got a witness in Lance Twiggs who puts him on scene and confirms that he's there. They've got kind of incidental evidence that supports the narrative that he's going back. He texts, I'm going to go back and get the gun. Stop with an officer on the street that's on the way to go get the gun. Turns himself in, makes admissions about destroying the clothes. So the alternative explanation will, I'm sure, come when the defense drops their brief. We'll take a look at it and see exactly what their arguments are. And if their evidence creates reasonable doubt, we'll talk about it, of course, because we give both sides a fair shake. We do believe in the presumption of innocence. We don't want innocent people going to jail. We don't want guilty people going free. And that's the beauty of the system that we believe in, is you've got two sides duking it out. We can analyze the evidence and unpack it here together. So we're going to continue to do that. And when the additional documents drop, we'll see what they look like. Thanks for joining and subscribing as we do. All right. So friends, that's the day. What a beautiful morning it has been. Let's see what you guys say about all of this. Let's see what you say about all of this. And we got some new members coming in, man. Amazing. Oh, and Sev Russ, man, look at these big fat donos. Oh my goodness. You guys are amazing. Amazing. Okay, so we had some comments here today. Amazing. Sev Russ, look at this, man. Thank you so much. Sev Russ, the 55-mile man. Great to see you. What's going on, Sev Russ? Thank you for the diaper fund, my friend. Very nice, generous dono of you. We'll add it in there. I'm sure this baby's going to be crapping all over the place when it comes, but not here yet. We're super excited. Alexis had a little bit of like tingling going on this morning. She's like, I don't know, something may be happening. So she's resting, she's relaxing today. So, take it easy, and we'll see if this baby comes. But maybe the baby will time it for this weekend, when we're not live streaming. It might be nice of the little child. Thank you, Sev Russ. Very generous of you. Really grateful to have you here, my man. Thank you for being here and for supporting us. Great to have you. We appreciate it. And we'll use it. Lots of diapers, I'm sure. Hey, and Jeannie Knees. Jeannie Knees. Baby. Not yet. I know, not yet. We went to a dinner last night, and she's like about to pop. Everyone's like, "Are you gonna have your child here?" Like, maybe, maybe. Come out right at the dinner table. Thank you, Jeannie. And Mock Schnell, man, thank you guys. We got some really nice generosity today. So thank you so much for sending this in, Mock Schnell. Rob, I am glad you and Alexis are both doing great, and I know you were anxious for the little one to be born. I missed the baby shower, so we'll just do the dono for the Diaper Baby Fund here right now. We missed you, Mock Schnell. We had a great time. Yeah, we had a great time. It was a lot of fun. Watcher fam, you guys really showed up. It was really special. We thought it was awesome. Our family was blown away. Our friends were blown away. Like, look at all these people here. I know, man. It's a beautiful thing. We got so many good people here. So, Mock Chanel, thank you for that, man. Extremely generous. So we're going to buy lots of diapers. And I'm going to have to change them. I'll change them. I'll have to change them. I'm going to love this little creature. Severus, thank you, man. So we're going to have lots of diapers. Thank you guys for kicking us off. Mock Chanel, we missed you, but we'll have many more baby activities. I'm sure of it. So we'll be back on that. Mock Chanel, again, thank you. I don't even know what to say. So generous. I'm so grateful for you. And Severus, thank you guys. Mock Chanel, hey, also bringing in members. We got Gerbers here. We got Miss Rex Murphy, what's up? Elizabeth Stretty, Terry Ruff, what's up? John Thomas. We got Christina Worley, Frightened in MA, what's up? Retired 5-0. Put the birth on Calshi, hilarious. That's pretty funny. Wolfpack, what's up? D's Pep Shed, what's up? Dreamscope, McFly's Gaming, Liberty, Capaho in the house, Dog Mama, Christian, we got In Cahoots, what's up? Carnivore Brent, Kevin Yocom, we got Fragile Thinking, and Arlene Miller Johnson. All gifted members in the morning. And we're excited to see you on our next members only morning stream, which will be tomorrow because we're coming back tomorrow. Retired 5-0, I can't wait to see Kyle tomorrow morning. Are you thinking about Hans? We've got Hans Monkey scheduled for tomorrow morning. So which Kyle are you talking about? Did we just get the names wrong? Well, hopefully I'm not disappointing you. But we've got Hans Monkey who's coming tomorrow. Hans, you know this guy. Very sharp dude. We talked about him a while ago. We've talked about him a lot, actually. Shared some clips of him. Hans Monkey's coming over. He just founded a new organization called the Counter Lawfare Institute. He wrote a book called Swift Boating America, which we talked about. Russiagate, Russia collusion, Crossfire Hurricane. We looked through that a while ago. That's how I came across him on that book. But he's been following the Fauci stuff, man, in depth for a long time. So we're going to ask him about that. Going to ask him about counter lawfare. We need to support our counter lawfarians. It'll be good. So that's who we got tomorrow morning. Retired 5-0, 10 a.m. Eastern time if you care to join us. And it'll be good. He's doing good work out there. So we want to see what he's up to. But thank you, Retired 5-0. If you're looking for another Kyle, let me know who that is, and we can line them up next if you're wanting to get somebody named Kyle on. Kyle Seraphin from FBI. That's what I'm thinking of. Psychological projectionist. Dems using the world's poor as a political weapon. Yeah, that's, I think, always what they do. Yeah, they want to make and create victims so that they can promise the victims a solution, and then the victims will vote for the Democratic Party. The worse you can make things, the more the Democrats can create a response. It's like the Hegelian dialectic, like create the problem, offer the solution, and then the resolution is you have more power. Yeah. Psychological, good to see you. Hey, Kuda. Hey, my first time to ever catch you live. Thank you for breaking all this court stuff down. It is helpful. Watch you for months. Thank you again. Great job, and God bless you. Kuda, thank you, man. Glad you joined us live. Yeah, we're a little bit early today. We've got some activities this afternoon that are anchored in there. And so we're glad we got to see you. Thank you, Kuda, for watching. Thanks for sticking around. Hey, my fix for the anchor baby is fine. Baby is a citizen, but the mother is not. So tell either take your baby with you when you go or leave with a citizen. So in other words, we keep the baby. I think the question is, how can we care for like 10 million babies if we don't, all of the illegals who are here, they drop babies, then we deport the illegals, then we got to take care of these kids. And I don't know that we can do that. So they got to take the kids. I mean, it's really what it is. Got to take the kids. But then they say, oh, you're violating a citizen's right. Well, that kid can come back when he's 18 or whatever. But otherwise, one way to do it is to just declare an invasion under the Citizenship Act Anybody who came in illegally is an invader. They're not a transient migrant. And so it's outside of the Supreme Court birthright citizenship matter, not a 14th Amendment issue. It's an Article 4 issue. And they don't get counted. CUDA. But I like the theory. Got to do something. Hey, Tara, what's going on, Tara? Welcome aboard as our newest supporter. And that's so weird. You've been a member for 38 months, but it says you just joined. So that doesn't make any sense. My granddaughter came early, 4 pounds on the 23rd. Congratulations to you guys. New baby in the house, a real one. Absolutely outstanding. Congratulations. New grandbaby in the house. How fun is that? Good to see you, Tara. Congrats to you guys. Hopefully mom and dad are doing good and you're having some fun. Hey, Denise Osborne. What's up, Denise? Thank you, Denise, for being a member. Thank you for the nice donation as well. Very nice to see you. No comment on that, but we're glad you're here, and you have a beautiful profile picture of a nice little yellow daisy, maybe. I tried. Thank you, Denise. Very nice and very generous of you. And let's see if we got any other comments on locals, and then we'll wrap it up on the day. We'll come back tomorrow. Should be on the regular schedule tomorrow, presuming we don't have a creature that drops out and is here. Yeah, and then my whole demeanor might change. I might look like I'm slobbering all over myself in the foreseeable future. We'll have to see. Hey, Liberty, just finished the bar yesterday. Let's go. Congratulations to all of our bar sitters. Feeling pretty good. One of the essays was crazy, but I think I got the main issues that they were testing. November 6th is the day. Let's go. When I checked in for the bar, they asked for my government ID. That's weird. For some reason, the check-in desk didn't think it was funny when I said it was racist to ask me for ID. Yeah, you're get arrested on your bar exam day. Hilarious. I noticed this guy's causing disorderly conduct here. Cops, come get him. I noticed it wasn't only white people taking the exam. How is that possible if people aren't smart enough to get an ID? Oh, that's great. I don't know. You might have to ask Kamala Harris for that one. I've always thought that all people can go get an ID regardless of color or gender or whatever. But the Democrats don't. They think if you're like black or brown or something, it's like rocket science to go get an ID. But apparently they're wrong. They showed up to the bar. So that's good validation. Thank you, Liberty. Hilarious. Hey, and Michael Swisher, I saw this. We didn't work this one in today, but I wanted to work it in at some point. 75,000 non-citizens called for jury duty in New Jersey each year. Insane. Non-citizens. I think we mentioned it earlier this week, but Homeland said that. Yeah, so they'll send you to jail. Non-citizens. And Paul is wasting no time, says Tobo. Rand will be sending a Fauci contempt referral directly to the DOJ, circumventing the attempt to block it. I've been seeing some of that. Well, hopefully we get some actual documents in writing. And when we do, we're going to enjoy that, man. We had a great time with you guys yesterday. We were live for 6.5 hours yesterday covering Fauci. Shout out to Joe. Good logic. We're going to post that interview as well. And Sandy, a couple of nice comments from Sandy, says, hey, great test case for the alien terror court. Yeah, it has the aspects of 2 categories, 1 family member of a terrorist, 2 permanent residents. It helps that the family member also committed acts that fit in the requirement. Yeah, son was like a terrorist, admittedly. Hey, Rob, something is hinky about the judges on the alien removal court. They are supposed to be staggered by 1 year, but it looks like Robert waited to see who won the election before appointing the 24 expired seat, 2 seats in 25. That's interesting. Yeah, that's interesting. I don't know much about those judges, but hopefully we get a lot more of them, a lot more information on them. Yeah, thanks for flagging that. I'll have to keep my eye on that, Sandy. So also says, President can adjourn Congress if 2 chambers can't agree on a recess. Many senators are on board to stay. Trump should make it clear that all recess appointments will take place, and I will adjourn Congress until January 3rd if the SAVE Act doesn't pass. Yeah, man, that's an interesting comment. So if 1/3 of the senators, who makes the final decision? It's probably the Senate Majority Leader. So Thune, does he get the decision according to their rules? And if they agree with the recess, I like it. I'm for it. I think Trump should really flex around, really flex as hard as he can. He's getting, he's not happy about it, but I don't think the senators care. It's Murkowski, it's Collins, it's Tillis, it's Cornyn, it's McConnell. They're just, what are you going to do to us? Tillis and Cornyn are out. McConnell's dead. Murkowski has perpetual power in Alaska because of their ranked choice voting. Collins is probably going to beat whoever the Democrat is because all of their candidates are like rapists. So I think that they're just kind of what are you going to do? Nothing. and they're just biding their time, unfortunately. So, friends, it's been a lovely stream. Sandy, Johnson will side with the House and the Senate won't agree. Trump can then adjourn them until a time he sees fit. Love it. From Sandy, thank you for that. And we'll wrap here. We've got CR Citizen says, where is amnesty a proscribed authority in Congress or any legislature? Amnesty is ex post facto, which is prohibited. Look at the Constitution. It's after the fact. Maybe with their ability to set rules on like naturalization, probably tucked in there somewhere. Article 1, Section 8, maybe the power to set naturalization rules. It might be in there. I might be making that up. But anyways, thank you, CR Citizen, for saying what's up. Our amazing mods, thank you so much for modding the fort down for us. Hey, Maybe Sunshine, 53 months, Maybe Sunshine. That's a big one. What a lovely day it is. Thank you for sending that one in. Sending love and health for you, Alexis and Baby. Great to see you. And thank you. We'll take it. We need it. We need some good love and energy because we're about to go through the thick of it right now. It's getting close. It's getting real close. Hey, and Spuds, I don't think your dono showed up. Oh, there it is. Is there any difference from homegrown terrorism versus permanent resident terrorism? Well, the homegrown terrorism, I mean, I think you could make the argument for both of them. The FBI said that there was like homegrown domestic violent extremism, and that was largely, according to Biden's FBI, the pro-lifers who would go to abortion facilities. So it kind of depends on who's doing the defining. But what we saw, I think, is exactly, we just imported these Afghanis, and then they turned into little ISIS actors. Not good. So what a lovely stream. All right. And Gina, thank you, Gina. Thank you for the nice comments. Glad you were with us all day yesterday. It was a lot. It was a lot, but a good one. Hey, Denise, thank you. Amazing. Denise, Alaska conservatives are fighting hard. All good stuff. All right. So we'll pause here for the day. We'll come back tomorrow. Members, 10 a.m. We're going to have Hans Monkey on for a good interview. Very sharp dude. He's been on the COVID stuff about as hard as anybody I've ever seen, and other things that he's working on. We'll talk about it. Then we'll come back tomorrow evening to get into it again. Of course, presuming that we don't have a baby emerging out. But until we're back here, I hope that your day and your rest of your evening is outstanding. Big thank yous to our mods and meme smiths. Thank you to K Bean in the house. We've got John, Muffin Rando, Donut Mind Me. We got Neuro D, Janek, Dog Digger, Geegum Geegum, Elliot, and Just Rhonda. All modding the fort down for us, keeping things nice and orderly. And my friends, I hope your evening and afternoon and sleep are peaceful and pleasant, and you return back here tomorrow to get into it again, because we'll be here. And in order to do this appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system, with the hope of finding justice. Make it a beautiful night. Sleep very, very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide, fighting for freedom with nothing to hide. So drop a like and don't forget to share, and bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through